No, your lordship.
No, let us come to.
My lord.
15. Uh, 17.
My lord.
Come to 16. Subject to pecuniary or other limitations prescribed by any law for recovery of immovable property with of so and so, then come to B, for partition of immovable property shall be instituted in a court within the local limits of whose jurisdiction the property is situated, provided that the suit is to obtain a so and so compensation, immovable, held, or by anything, and where the relief sought for can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction the property is situated, or in so and so. Now kindly come to 17, where there are two properties situated. And fight it out, fight it out. Where is the Joran?
Let it be on next week. I'll.
Good weather, good weather.
Your lordship.
Joran, there's a lovely tea gardens nearby, good weather. Go and fight out there.
Your lordship kindly.
Don't remain out here within the confines of these concrete jungle.
Kindly take it in next week. I'll satisfy your lordship.
I wanted to fix it next week,
My lord.
but your junior said don't fix it. He wants to do the matter.
My lord.
Ask him. I said that.
Sorry, I accept apology on behalf of him.
No case.
My lord, I have a case. I'll satisfy your lord. Let me,
No.
my lord, give me some time.
When is the next date fixed?
And then next date, 15th of May.
At the request of the Learned Council, the matter stands adjourned to be listed on 14th of May.
Give you.
For admission, item 5.
Yes, what are you challenging?
Yes, my lord, revision petition, I have silenced the order dated 23/8/22, my lord, whereby rejected the setting aside the application for setting aside the ex parte order. My lord. Page 44, my lord.
49 to. Let's go.
It was filed during the COVID-19 pandemic, my lord. And it was
COVID-19 pandemic has ended.
ended, my lord.
So don't come up with that.
But some restriction, my lord, thereafter, my lord, for court functioning, my lord.
Is your written statement ready?
My lord, ready, my lord.
7 days.
My lord,
We allow his petition.
my lord,
Makes no sense.
my lord.
Unnecessary complications. Let him file. Be
Yes.
happy. Fight it
Delay
out.
of 240 days. Delay of 240 days.
Huh?
240 days, my lord.
Understood. 240 days he has filed. He did not appear on 8/10. Na?
No, my
8/10.
lord, not only one date, my lord, after COVID pandemic, he appeared, his sick time, there for 2 dates, and thereafter did not appear.
Hello? Okay. Cost of 25,000. 25,000. Make it 30.
My lord.
30. You're lucky. Your opposing counsel wants to make it 30. Okay, heard Mr. K. Padgiri, the learned counsel appearing on behalf of the petitioner. Miss
S.G. Borua, my lord.
S.B. Bulwa, the learned counsel appearing on behalf of the respondents. The petitioner has approached this court challenging an order dated 23/8/2022 passed in petition number 240/22 arising out of title suit number 18/2020 by the court of the learned Munsif number 2,
Lakhimpur.
not Lakhimpur, whereby the application under Order 9 Rule 7 for vacating the ex parte order was rejected. Full stop. The learned counsel appearing on behalf of the petitioner submitted that the order date by the order dated 8/10/2021, the suit was proceeded ex parte against the petitioner, who was the defendant number one. Full stop. However, on account of full stop, he submitted that the learned trial court did not take into consideration that the petitioner was an old aged lady and had to undergo treatment for knee and head injury, and medical certificates were also enclosed therewith. Mr. K.R. Padgiri, the learned counsel appearing on behalf of the petitioner, further submitted that a perusal of Order 9, Rule 7 of the Code would show that what cause was required to be shown was a good cause and not a sufficient cause in terms with Order 9, Rule 13 of the Code. He therefore submitted that the learned trial court, or in exercise of its jurisdiction in rejecting the application under Order 9, Rule 7 of the Code. Additionally, the learned counsel submits that the written statement of the petitioner is ready and can be filed on such date as this court may direct. Full stop. Per contra, Ms. So-and-so appearing on behalf of the respondent submitted this is a case where the petitioner herein have duly received notice, summons, and thereupon had appeared on 2 occasions and thereafter did not appear. Full stop. The learned counsel submits that action on the part of the petitioner is nothing but a clever ruse played to get away from the mandatory period of 90 days, which is granted for the purpose of filing the written statement. Shri further submitted that if the petitioner would have very well filed the said application on the date on which could have filed the written statement on the date on which the application under Order 9, Rule 7 was filed, and the court would have, the learned trial court would have duly considered the same. But however, in this process, the suit have been delayed by more than 3 years, 5 years. This court have duly heard the learned counsels appearing on behalf of the parties and have given its anxious consideration. From the materials on record, it is seen that the petitioner had filed the application under Order 9, Rule 7 of the Code on 21/7/2022. And wherein it has been stated that the petitioner, who was a 65-year-old lady, had to undergo surgery on account of her knee being broken. To the said application, the medical certificates were also enclosed. First, This court cannot also be unmindful of the fact that during this period when the court passed the order of ex parte, that is on 8/10/2021, the COVID pandemic was going on. And during this period, and there were certain restrictions on the movement of the senior citizens. This court further have taken note of that the right to file the defense written statement is a substantive right, and the same should be can though be curtailed, but and the same is a substantive right, and the procedural laws being always subservient to the to substantive rights, the learned trial court ought to have duly considered the application under Order 9, Rule 7 to be falling within the ambit of a good cause for permitting the petitioner to participate in the said suit proceedings and filing the written statement. First, accordingly, this court interferes with the order dated 23/8/2022, whereby the application seeking vacating of the ex parte order dated 8/10/2021 was rejected. First, this court cannot also be unmindful of the fact that the application under Order 9, Rule 7 was filed in the month of July 2022. That is, after almost 9 months. First, this had occasioned considerable delay in the disposal of the said suit. First, under such circumstances, it is the opinion of this court that the petitioner, that the respondents, who are the plaintiffs, are required to be compensated for the loss during this entire period as the suit proceedings continued. First, accordingly, the instant petition stands disposed of with the following observations and directions. Number one, the order dated 23/8/2022 is set aside and quashed, and the application being petition number 240/2022 filed by the petitioner is allowed. Number two, taking into account the petitioner herein, this court imposes a cost of rupees 25,000 upon the petitioner, which is required to be deposited. Number two to the this. It is seen that this court, by the order dated 27/9/2022, had stayed the further proceedings of title suit number 18/2020 pending before the learned court of the Munsif number 2, Lakhimpur at North Lakhimpur. The said stay order is vacated. Full stop. The petitioner is given the liberty to file her written statement, is vacated, and the suit is fixed on 4th of June 2025. Full stop. The petitioner is given the liberty to before the learned trial court. The petitioner is given the liberty to file the written statement on or before 4th of June 2025. Full stop. In doing so, full stop. In doing so, full stop. Number next. This court further imposes a cost of rupees 25,000, which has to be deposited by the petitioner before the learned trial court, and the said cost shall be a condition depositing, and the depositing of the said cost shall be a condition precedence for the acceptance of the written statement. Full stop. The number 5 is the petition, the respondents herein, who are the plaintiffs, would be at liberty to file an application for release of the said amount, and the learned trial court shall pass appropriate orders.
My lord,
Obliging.
my lord, subject to correction, they have appeared 4 dates, my lord, not 2 days, 2 days prior to pandemic, 2 days after pandemic.
Item 6.
It is regarding the WS filing, my lord.
Hmm.
There is a delay of 60 days is there. Apart from the statutory limit of 90 days.
Item number 6. What are you challenging?
My lord,
What are you challenging?
challenging the order is that order is at page 32. 3/3/21.
What is the other one? Why a suit has been read?
My lord, other case was filed by the defendant, who got the decree against this plaintiff. And the execution process also started. But somehow the execution could not be proceeded. And in the meantime, the present suit he has filed. And he was very much there as a defendant in the earlier suit. That suit was contested by him.
What is page 26 and 27? 27 is an affidavit.
27 is the affidavit. And 26 is the application, order 907.
Then you file this petition when? 1/8.
On 1/8.
Yes, Mr. Talukdar.
My lord, in fact, the ex parte order was passed on 27/6/19. Hereafter, that was not challenged. Again, a petition was made before the learned court below. And that petition was made on
1/8.
1/8.
Hmm.
1/8.
1/8. So meanwhile, after that rejection petition, only this revision has been filed. Now they have been, the order is in fact explicit. It is a speaking order, the 3/3 annexure. Yes. Yes, Lordship, Annexure B at page 24.
Page 32.
Page 25 is the handwritten copy. Typed copy
No,
is
that
at
is
24,
okay.
page 24.
That is okay.
So plaintiff and defendant number 1 as well as 2, 3 are represented. They were there. One petition has been filed by the defendant counsel of the learned counsel of the defendant number 1 praying for another date. However, perusal of CR reveals that the summons to the defendant number was served on 22 to 19. Hence, it has been,
No, that is okay, Mr. Kalukdar.
yes, Lordship.
First of all, filing an application on the order, why an ex parte proceeding is given, that the court cannot otherwise proceed
Lordship,
unless it says that we'll proceed ex parte.
yes.
On that date, there cannot be the suit shall proceed ex parte. No, it cannot be. On that day, the court passes an order that it shall will
Yes.
proceed ex
Yes,
parte.
Lordship.
And the next day, the defendant can very well appear. But if he shows good cause, then the defendant can bring the date back to 27/6. Oh, what is the date?
Anyway, Lordship, that order,
27/6.
my Lord may kindly look at last but one para. However, the defendant number 1 is at liberty to take part in the cross-examination and put forth arguments.
So there is
So
no
order
necessity for challenging that order of ex parte, not necessary. What is required is for setting aside the ex parte, one can do so. And if
Yes.
an application is being filed, which is being filed out there, stating
That
that
is
these
the-
are the reasons
Otherwise,
why.
defense is a right. Otherwise, defense is a right. It is up to your Lordship, as your Lordship pleases.
25.
My lord,
25,000.
she's a housewife, my lord.
So what?
Yeah, she's a
Can't help it.
lady and no other.
Then somebody else will come up. You sacrifice your fees, don't take that.
No, I have
Give
been
it to
engaged
them.
only in the high court, my lord. I was not there in the trial court. My
Oh, then. Now 25,000. Earlier case I have allowed 25,000. That was a 65-year-old lady. Here also same. I heard Mr. J. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. L. Talukdar appears on behalf of the respondents. First, the petitioner herein has approached this court challenging the order dated 3/3/2021 passed by the learned court of the Munsif, number 2, Kamrup Metro at Guwahati, in title suit number 43/2019, whereby the application filed under order 9 rule 7 of the court was rejected on the ground that the cause shown in the said application was not a good cause. Full stop. This court have duly perused the said application, perused the order dated 27/6/2019, whereby the learned trial court, taking into account that the service of summons was duly effected on 22/2/2019, and the written statement was not filed, have proceeded with the suit to the stage of ADR/issues, thereby fixing the matter on 1/9/8/2019. First up, on the next date, an application was filed by the petitioner stating the grounds on which the written statement could not be filed on 27/6/2019 and 19. First up, the respondents herein had filed their written objection to the said application. And pursuant thereto, the learned trial court had passed the order dated 3/3/2021, whereby the application under order 9 rule 13/7 was rejected on the ground that the cause shown was not a good cause. Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner, had submitted that there was no negligence on the part of the petitioner And it was on account of her illness and the sudden death of the uncle of the petitioner could not file the written statement. The learned counsel further submitted that insofar as between the petitioner and the respondent, another suit have already been decreed in favor of the petitioner, which is presently pending at the stage of execution. And as such, if any ex parte decree is passed in the instant proceedings, it would seriously impact the rights of the petitioner. The learned counsel further submits that the written statement of the petitioner is ready and can be filed on any day as this court may direct. Mr. L. Talukdar, the learned counsel appearing on behalf of the respondent submitted that a perusal of the order dated 27/6/2022, 21, na? 19 would clearly show that the written statement was not filed within the mandatory period of 90 days. And as such, there is no error in the learned trial court proceeding ex parte against the defendant number 1 / the petitioner. Full stop. He further submitted that the cause which have been shown in the application under Order 9 Rule 7 under no circumstances can be said to be a good cause for for putting the clock back to the stage of 27/6/2022 to 19. This court have heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. Materials on record surprises this court before discussing on the merits of the instant case. This court finds it relevant to make an observation that the application filed under Order 9 Rule 7 was filed on 1/8/2019. And it surprises the court that it took more than 1.5 years for the said application to be disposed of by the impugned order dated 3/3/2021. Be that as it may, this court further takes note of, be that as it may, on the facts it is seen that the learned counsel, that the petitioner herein have assigned the cause that she could not file her written statement on account of her sudden illness as well as the death of her uncle on the date so fixed, that is on 27/6/2022, 19. The learned trial court merely stated that the said not to be a good ground without taking into consideration as to whether the petitioner herein was actually prevented by a good cause on account of her illness as well as the sudden death of her uncle, more so when medical certificate was duly enclosed.
There, that was not enclosed.
It is enclosed, this one.
Here, let's say prescription and one, there is nothing like the petitioner needed rest.
Hmm?
The annexure
medical.
F and G, let's say.
In addition to that, this court also finds it relevant to take note of that the procedural laws are always subservient to the interest of justice. And as filing of a defense is a substantive right, comma, the learned trial court ought to have exercised its jurisdiction thereby in a manner ought to have duly exercised its jurisdiction by allowing the petitioner to file the written statement by imposition of certain cost. Full stop. Taking into account the above, next, this court cannot also be unmindful of the fact that on account of that there is a period mentioned within which the written statement is required to be filed. Full stop. The petitioner, even while filing the application under Order 9 Rule 17, did not submit the written statement. Full stop. The above, therefore, shows certain negligence on the part of the petitioner. Full stop. It is the opinion of this court that such negligence can be countered by way of certain compensation being paid to the plaintiffs oblique the respondents herein. Accordingly, this court disposes of the instant petition with the following observations and direction. Instant petition with the following observations and directions. The order dated 3/3/2021 by which the application under Order 9 Rule 7 was rejected is interfered with. Number 2, the petitioner is given full stop. This court have duly taken note of that by an order dated
Petition 6.
4/4/2023, the further proceedings of the title suit number 43/2019 pending before the court of the learned Munsif number 2, Kamrup Metro at Guwahati was stayed. Full stop. The said stay order is vacated. Full stop. This court further imposes a cost of rupees 25,000 upon the petitioner. Now, this court grants the liberty to the petitioner to file and vacate it, and the parties who are duly the parties as they are duly represented before this court are directed to appear before the learned trial court on 4th of June 2025. Full stop. Liberty given to the petitioner to file her written statement on or before 4th of June 2025, comma, full stop. The petitioner herein is imposed the cost of rupees 25,000, which has to be deposited before the learned trial court along with filing of the written statement. Full stop. The imposition of the deposit of the said cost of rupees 25,000 shall be a condition precedent for acceptance of the written statement. Full stop. The petitioner respondent herein, who is the plaintiff, would be at liberty to file application for release of the said amount, and the learned trial court shall pass appropriate orders.
Item 7.
This matter we have come against the rejection of the paternity test of the petition. On the last occasion, your lordship has already heard this, and then your lordship has even indicated that the paternity test part should be done as a last resort in the basis of a judgment that was of Ivan Rathin, your lordship. On that occasion, I have also seen. Then your lordship has given me time to consider whether that can be done or not. Because this matter, your lordship said that it should be sent back to the court, wherein evidences which has not yet been done. The evidences.
It is
which are-
only after the evidence is
Yes.
laid
That is what I
and
understand.
the evidence having not been conclusive,
Yes,
then only the paternity test will come into picture.
because what has happened here, two birth certificates were given. One was given by me and the other was also given by the other. So that was the issue. Therefore, we asked for a paternity.
No, you have
test.
to give evidence.
Yes. Now that day your lordship has indicated that you further give the evidence, prove if that after that, take it as a last week. And I have also talked and they are agreeable to that. So the only thing your lordship. with the
I will do one thing.
Yes,
I'll record it that you want an urgency on the matter. And as such, you will be adducing evidence, taking into account that. So you'll be adducing evidence. And the learned trial court shall expedite that issue as regards this, taking into account, and this trial court shall expedite the issue that is,
yes. The only thing will be the order already, rejection order is there, that has to.
no, that has to be, yeah. Where's the judgment? I gave it to you, this
That
Rathiram or what is it?
judgment, actually, I got the judgment. I think this is Ivan Rathinam in paragraph 47. I have got.
Give it to me.
Uh,
I lost it
this is
somewhere.
over the mic. Give it. আছে নেকি তাতে? কিন্তু মোৰটো দি দিছো। I
Okay.
think it is there.
Well, in this issue, Lordship, you have already decided some cases, Lordship.
What?
So in similar situation, Lordships, your Lordship decided some cases, Lordships. I have the husband, your Lordship's husband, Lordship.
What do I do? What did I do?
Yes, Lord, your Lordship.
He already-
Oh, that's the judgment of,
Yes,
in,
yes,
in the case of Mr. S. Dotto.
Yes, Lordship.
Yes, it doesn't.
Your Lordship.
Oh, I regard the DNA testing, no?
Lordship. Similar situation, Lordship.
Paragraph 9, no?
Lordship.
The exposition of law above quoted and applied to the facts involved in the present case in the opinion of this court would show that the application so filed by the petitioner before the trial court was premature. The law declared above categorically mandates that the direction for DNA testing can only be permitted when the learned court, after perusal of the evidence, finds the evidence is not sufficient to conclude the legitimacy of
Yes,
paternity.
this is what.
In addition to that, the learned trial court thereupon has to arrive at a finding as to whether the DNA testing test is the best, is in the best interest of the parties. In the instant case, the evidence of the parties yet to be laid in the entirety, and under such circumstances, the question of consideration of the said order could not have arisen. In addition to that, this court further takes note of the provisions of so and so. Considering the above finds no merit in the year, according to the year, interim order is vacated and further proceedings of so and so. So we take care of only 9. 9.
And that part, your lordship, with regard to evidence. In my case, no
And,
evidence. has
and,
been-
and the order which is being passed shall not influence the learned trial court. I'll say that the application was premature. And as such, you, after adducing evidence, you are again at liberty to file an application. And then the learned court shall take its law in its own course. I think that is the best way of.
But the evidence should be on the basis of the paternity, sorry, of the child, basically on that. Because this is otherwise, this is a guardianship matter. In this,
Whatever, this is also that was another case. That was not a guardianship. Here he says that he is not the son of the father or something to that effect. Paternity, both paternity business only, and therefore he filed an application for paternity test. Now the suit was at the stage of evidence only. There is no evidence done till then. This is the situation. Heard Mr. Y.S. Manan, the learned counsel appearing on behalf of the petitioner, and Mr. So and so appearing on behalf of the respondent.
Yes, 120.
Huh?
120, Lordship.
1, 2, and 1 has died, na?
Lordship, yes, Lordship.
How are you appearing for dead people?
No, Lordship. After filing my Appellate, he died, Lordship.
Oh, so
Yeah, he was-
renumbered as 1, 2, and
Yes,
3.
yeah, after he was strike out.
Respondent's number, here's on behalf of the respondent number. Renumbered respondent numbers 1, 2, and 3. The petitioner herein have assailed the order dated. Which order?
Page 91. Dated
The
5/10/2024. 5/10/2024.
5/10/2024 passed in Mizzi case number 45/2023, whereby the application so filed by the petitioner seeking DNA test seeking scientific test as required, a scientific test for determining the parentage of the child, Mohammad Ayan Wafidu Rasid, alias Mohammad Anas, was rejected. Full stop. This would, Mr. Y.S. Manan, the learned counsel, submits that taking into account the recent judgment of the Supreme Court in the case of Ivan Rathiram versus Milian Joseph, reported in 2025 SCC Online SC 175. The stage at which the petitioner had filed the application seeking DNA testing of the child appears to be prematured, inasmuch as without any evidence led, the learned court of the principal judge, family court number 3, Kamrup Metro, Guwahati, bracket here for the learned trial court, could not have come to a determination as to whether the scientific test was required. He referred therefore to paragraph number
I think 47 in my.
47 and 51 of the said judgment. He therefore submitted, the learned counsel therefore submitted that the petitioner herein would adduce evidence and thereupon, if there is any requirement, the petitioner would file again a similar application, and this court may pass appropriate orders to the effect that if such application is filed at a later stage, the learned trial court shall consider the said application without being influenced by the impugned order dated 5/10/2024. Full stop. The learned counsel appearing on behalf of the respondent submitted that he has no objection taking into account the law laid down by the Supreme Court in the case of Ivan Rathiram Putra. Full stop. In that view of the matter, the instant petition therefore stands disposed of, with the observation that the petition so filed by the petitioner seeking scientific examination oblique DNA test of the child was prematured at the stage when the impugned order dated 5/10/2024 was passed. This court grants liberty to the petitioner herein to submit evidence proving his parentage over the child. First, upon such evidence being adduced, the learned trial court shall give due opportunity to the respondents to adduce evidence. And thereupon, if it is found necessary, the learned trial court shall afresh decide the application filed bearing petition number 2614/2024. First, for that purpose, this court holds that the impugn order dated 5/10/2024 is for that this court interferes with the order dated 5/10/2024 insofar as the petition number 2614/2024. Oh, no.
45.
Insofar as the petition number 260, isn't it? 260, na? 260/2023. Insofar as petition number 260/2023 and restores the said petition being petition number 260/2023 to the file of the learned trial court. Full stop. The decision on the said petition number 260/2023 be full stop. The learned trial court shall adjudicate the said petition number 260/2023 if found necessary after the adducing of evidence by both the parties. Full stop. Before parting, this court further takes note of the submission of Mr. Y.S. Manan that the petitioner herein have been deprived of meeting his child, and as such, an appropriate direction be issued to the learned trial court for an early disposal of the misguardianship case number 45/2023. Full stop. This court, taking into account the facts, would request the learned court of the Principal Judge Family Court number 3, Kamrup Metro at Guwahati, to decide the said application being misguardianship case number 45/2023 at the earliest as per the business of the court.
That's all.
I didn't require you to file another application. I restored that application, keeping it here. So it is not required. So once I have interfered.
Now we can go and give our evidence. Much.
Item 8.
Yes, Mr. Khan.
My lord, this appeal for enhancement. On the last occasion, your lordship wanted to
Oh, yes.
take its action
He wanted something, something, yeah. What is that?
regarding lordship,
The interest from the date of filing claim.
interest is given from the date of filing of evidence. But our claim is that it should be from the date of filing of the claim petition. So this is one. And secondly, another ground lordship, notional income is taken only 6,500.
You didn't give any evidence.
Evidence, yes, there is.
You did not give any evidence.
And
That is the only point why I asked.
That's
Finished. He'll be giving you the interest as per this. With this point.
Yes.
You filed your wakalatnama, na?
yes.
Then matter over. At the end of the day, you want to only the interest. Interest
Yes,
will be
yes, sir.
given from there. Unless keeping it pending makes no sense. Heard Mr. M. Khan, the learned counsel appearing on behalf of the petitioner, Mr. K.K. Bhatt appears on behalf of the
Respondent. Only one respondent,
respondent numbers,
only one respondent.
sole respondent. This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and order. Judgment and award dated 21/1/2025 in MSC case number 243/2022. The sole ground for filing the instant appeal is on the ground that though the learned tribunal had adjudged the compensation at rupees 5,87,800 along with interest at the rate of 6% per annum, but without assigning any reason, had granted interest only from the date of filing of the evidence by the claimant and not from the date of filing of the claim petition, which is the norm. Full stop. When the matter was listed before this court on 23/4/2025, this court inquired with the learned counsel appearing on behalf of the respondent, Mr. K.K. Bhatt. This court inquired with the respondent insurance company whether they would have any objection as regards the granting of the interest and as regards the said ground of objection so taken. First, today, Mr. K.K. Bhatt appearing on behalf of the respondent submits that the respondent insurance company would not oppose the granting of the interest at the rate of 6% from the date of filing of the claim petition. First, taking into account the above, this court therefore disposes of the instant appeal, thereby modifying the judgment and award dated 21st of January 2025 passed in MAC case number
3/20/22.
243/2022 only to the effect that the interest on the judgment on the compensation so awarded at the rate of 6% per annum shall be calculated from the date of filing of the claim petition and not from the date of filing of the evidence by the claimant. This court further observes that the other aspects pertaining to the said judgment and award, more particularly stated in paragraph number 13 of the award judgment of the said judgment and award, shall remain as it is. with the above the instance description.
Supplementary item 50.
Oh, this one.
That's it. Our affidavit has not come yet also. We have sent the affidavit come. It has not reached.
Okay, we'll have it next week.
My lord, I would like to file also affidavit because your lordship will find some fraud has been played. If your lordship allows me, I will take you to that chapter.
It's okay. You want to file affidavit next week?
My lord, then my lord, your lordship kindly give me 2 weeks time.
Okay, we'll have it on 23rd of May.
Yes.
So both the councils appearing on behalf of the parties submits that they would be filing their individual affidavits by 22nd of 21st May.
Yes.
21st of May 2025. List the matter on 23rd of May 2025.
Much obliged.
Hearing under the 51 Rule 11 CPC, item 10.
Yes.
Malad, just second appeal, Malad, substantial question has been formulated by. It was so if for declaration that the plaintiff is the LOT of the government land.
Hmm?
Yes. Plaintiff, Your Honor, as per plain case 53, prayer was made that the decree be passed declaring that
You are the plaintiff or the defendant?
the defendant.
You are the defendant.
Yes, sir. Plaintiff suit was for declaration that he has a legal right as allotment of the government land.
Proof for declaration that the plaintiff is the LOT of the suit land described in Iman below and recovery of khas possession. LOT of what?
A government land, my lord. As per allotment certificate, exhibit
Unless
1
person
shown.
He has no land for dwelling, so. the petition is
This is peculiar, my lord. After filing the suit, this exhibit 1 produced dated 5/1/2020. The suit was filed on 31. Suit was filed on 24/3/2015. So after filing this suit, land was allotted as shown at exhibit 1.
The decree. Then
The plaintiff cannot get such right title declaration of right title interest in this as per the exhibit 1 produced by the which is the wrong finding of both the courts below, because exhibit 1 is a allotment certificate shown dated 5/1/2020. Suit was filed earlier on 24/3/2015. This was overlooked by the learned court himself because as per allotment certificate, my lord, as per provision of law, your lordship, allotment plan, the plaintiff cannot get declaration of right title interest. As per
Has
the
the
allotment
plaintiff have not
only
asked
on the
for?
basis of allotment certificate.
the plaintiff have not asked for declaration of right title interest.
But the issue may be perished, Your Honor.
Huh?
Your lordships, issue may be perished, issue framed, landed court.
It's a different thing. It should
Case
have been
number
framed.
19, case 19 may be perished.
And what is your right?
Right, I am also possessing the land of the state government land.
Then,
Since long 20
so you
years.
have no right over the land.
I have also no right over the land.
Then,
Plaintiff has also no.
but the plaintiff defendant has some issue on the.
My lord,
Let us
defendant
see
is a
how does
dead
the
person.
title court look into.
My lord,
so and
defendant
so,
is
plaintiff
judgment is passed
on
in favor of a dead person, my lord.
Whether
Decree is
the
valid,
Iman,
my lord.
we will see issue number 3. Issue number 3, issue number 3. Whether the suit land was allotted to the plaintiff and the possession of the same was delivered to the plaintiff on so and so white book number so and so. And categorically stated that in Iman exhibit Iman reflects the record by the Mulligan district land by the report. PW four has also stated that he agreed for the existence of the- No case.
My lord, ground number B, I have made whether allotment certificate plaintiff can get the right
There is no declaration of any right title interest given.
section 154 of Assam Land Revenue Regulatory Bar.
His plaintiff's basic case is that he is a legal LOT. And that has been duly proved.
But he had no possession over the land. No delivery possession was, the recovery possession was also there.
The court has held that he was in possession on the basis of the evidence.
But as per evidence of Peter plaintiff, he admitted that he had no possession over the land.
On that day, that is why he filed a suit for recovery.
Ground number C, my lord, plaintiff, the judgment and decree was passed in favor of a dead person. He
Huh?
was in favor of dead plaintiff,
Why?
dead plaintiff, my lord.
How?
Ground number C, I have formulated in discussion.
Issue number 3, who is the plaintiff who died?
Jamaluddin, my lord. Yes,
Mohammad Jamaluddin.
yes, he's a dead person.
How do you know?
Yes, my lord. As per the petition filed by the respondent himself in a miscase under order 1 rule 10, CPC playing to implement them as LR.
Where in this case?
Yes, yes, my lord. By order dated 19/3/2025.
IA Lordship for implement. And thereafter, Lordship, after knowing that the Mohammad Jamaluddin sole respondent died, Lordship, they have filed objection in my petition.
No, wait.
And thereafter,
Wait, you filed an application here.
yes, Lordship.
When did he die?
Lordship, he died, I have mentioned. 3/1/2021. And decree was already executed, Lordship.
Executed.
Yes, Lordship, we got our
Decree
permission.
executed and the judgment was delivered by the trial court on?
After date, my lord, 12/1/2021. In ground number 7 formulated, I have lordship.
Where?
2/9/2023.
In the
He died on 3/1.
3/1/2021.
And judgment was delivered on
Second,
No,
2/9/2021.
12/1.
12/1/2021, my lord. Same.
Now, what does order 22 rule 7 say? Have you seen into that provision of what is order 22 rule 7 or 6? CPC?
My lord, the judgment was passed annexer, page number 35, my lord,
Ah,
of my memo of appeal.
so you filed an appeal against the dead person.
Lordship.
No, my lord. Appeal was, judgment itself was, my lord, page number 35, very clear.
Ah.
That will come clear. Page
Ah.
35, memo of appeal.
Ah.
Order dated 12/1/2021.
Ah.
Plaintiff shown is alive person.
Where?
Page 35, memo of appeal, my lord.
That's the file. Ah, yes.
Plaintiff shown is alive and present before the honorable court.
Ah,
So judgment was passed
Ah.
on 12/1/2021, showing that plaintiff is represented, but on the period of that, he was a dead, or he died earlier on 3/1/2021. How he can appear before the honorable court? He was a dead man. Judgment passed in the name of a dead person. The appeal was filed in the name of the dead person, my lord. That
you
subsequently,
filed an appeal against the dead person.
because I had no knowledge regarding the date when he died or not. But learned court of appellate court found that he was a alive person. No petition filed regarding constitution or implementation of the LR. So this judgment is nullity because dead person, in the name of dead person. Learned court did not show that he was a dead person, showing him as a alive. And before the trial, or before the appellate court also, no such fact brought before the appellate court that he died. No such petition filed under order 22 CPC or order 1 rule 10 CPC, my lord.
Mr. Counsel, have you seen Order 22 Rule 6 of the CPC?
Yes, my lord.
What is it?
Yes, my lord. Six, no abatement by reason of death after hearing. But whatever may be there, my lord.
No, read it properly. Don't come up with
Notwithstanding-
whatever may be
notwithstanding
there.
Anything contained in the foregoing rules, whether the cause of action survives or not, there shall be no abatement of any reason of death of either party between the conclusion of the hearing and pronouncement of the judgment. But judgment may in such case be pronounced notwithstanding the death, and shall have the same force effect if it had been pronounced before the death.
That.
Before the
Now you
death.
see, record shows on 19/12/2020, hearing was done, completed, judgment reserved. So that point also goes. And you filed an appeal against the dead person.
Now,
And you are filing the second appeal also against the dead person. What more can I say?
my lord, court himself shown that he is a alive person,
How?
showing him as alive because no such information to the fact.
But
of the
today,
fact
if
that
I say
plaintiff
I have
claimed
heard,
it was a
I
death,
have heard
either
the
is no-
petitioner, I have heard the appellant, whether the appellant is alive. Tomorrow are you going to say, oh, the appellant has died, but the court has given a certificate that he is alive.
Now, next question was, my lord, that suite itself was part not maintainable under section 154 Assam Land Use Regulation. Because it was the allotment and regarding settlement of land. Section 154 is very much clear that this is the entire regulation of revenue, my lord. Section 54 matters exempted from cognizance of civil court, my lord. Which says except when otherwise expressly provided in this regulation or in rules issued under the regulation, no civil court shall exercise jurisdiction in any of the following. A, question as to the validity
Mr.
of.
Counsel, did you raise such point in your written statement?
Yes, ma'am.
Where?
Issue is also
360.
there.
Page 60.
issue is also framed by that whether the suit is maintainable itself.
No, page 60. You did not raise that issue. To be a substantial question of law, it has to be based upon pleadings on issues and thereupon.
In the WSI.
Yeah, it's a
suit itself
simple
is not
case that he
maintainable.
was granted an allotment and when he was granted an allotment. But we need not go into all these things.
My lord,
You
here,
have filed an appeal.
another
against this
decision.
person.
the LOT has no right over the land.
You have filed an appeal against a dead person. Matter over. Your appeal, the judgment in appeal or anything has become non-est. Nothing is there.
Appellate court held that he was alive.
Appellate court.
No
did-
any information
Did
before the
anybody
appellate
appear?
court. Judgment was passed in the
Lordship,
name of
We have filed one
Appellate, my
application
lord.
before the appellate court, Lordship, in informing the death of the father, Lordship. And thereafter, Lordship, I have checked the LCR, that petition was rejected. That petition was incomplete information, Lordship. On that ground, the petition was rejected.
no, but
And
no
there,
death certificate
even
was not.
thereafter, Lordship, the appellant did not substituted the dead person.
Nothing remains.
And here I have filed implement application so that he can file substitution, Lordship. He filed objection and thereafter this court allowed my implement application.
I hope I did not. Okay, 2 o'clock we dismiss your appeal. Let me come back.
One decision of this honorable court, I thought, regarding allotment settle of the land. LOT has no right over the land, because the land itself was also not under possession of the.
He
There are
may
so-
not, the LOT may not have a right vis-a-vis any other person, against the government, but has a better right than you. Heard Mr. B. Hussain, the learned counsel appearing on behalf of the petition. Appellant. R. Chaudhary appears on behalf of the impleaded respondents. The present is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 2nd of September 2023, passed in title appeal number 4/2021, whereby the appeal filed by the appellants were dismissed, thereby confirming the judgment and decree dated 12/1/2021, passed by the learned Munsif number 2, Morigao, in title suit number 25/2015. Munsifৰ লগত আপুনি learned trial court আৰু আগৰটো by the civil judge Morigao in title appeal number so and so by learned first appellate court. The instant appeal is taken up at the stage of Order 41 Rule 11 to ascertain as to whether there is any substantial question of law involved in the instant appeal, which can be formulated in the instant appeal, and thereby to proceed thereafter. Full stop. For deciding the said aspect, this court finds it relevant to take note of the facts which led to the filing of the instant appeal. Full stop. One Muhammad Jamaluddin, who has been arrayed as a respondent in the instant appeal, had filed a suit being title suit number 25/2015 against the appellants herein, who were the defendants, before the court of the learned Munsif number 2, Moriga Munsif, before the learned court of the Munsif number 2 at Moriga. The case of the plaintiff in the said suit is that he was allotted a plot of land at measuring 4 katha, 13 lectures, covered by dark number 313 of Paliguri Gaon under Moja, Gova in the district of Morigaon, Assam, by an allotment letter number MRS 11/96/98 dated 5/1/2000, and possession was delivered to him for constructing a dwelling houses thereon, and dwell therein. The land in question, which have been more specifically described in Schedule A to the plaintiff, was a big ditch which the plaintiff filled up. Full stop. While the plaintiff was constructing his houses thereon, he developed cancer, for which he was under treatment at Dispur Polyclinic and Nursing Home, Guwahati. Full stop. Taking advantage of his absence, the defendants forcefully occupied the scheduled land without any authority. The plaintiff had requested the defendant to vacate the said land, but as the defendant did not vacate, the suit was filed. Seeking a decree that the plaintiff is the legal allottee of the suit land described in Schedule A, and he is entitled to occupy the same, semicolon. For a decree for recovery of khas possession of the suit land to the plaintiff, evicting the defendants therefrom, by dismantling and removing their sheds, construction together with their men and materials therefrom, for permanent injunction, etc. The defendants appeared in the said suit and filed their written statement, raising various preliminary objections as regards the maintainability of the suit. It was mentioned in paragraph number 13 of the plaint of the written statement that the defendants were possessing the land with constructing dwelling houses over the land covered by Dag number 313 or Paliguri Kisam since 20 years. It was also mentioned by the defendants that prior thereto, the said land was being possessed by Paresh Biswas, Sri Gopal Rai, Akur Ali, Indrajit Das, Hussain Ali, along with some other persons. And these persons had handed over the possession of their respective shares over the said land to the defendants. Full stop. On the basis of the pleadings, the learned trial court framed as many as 7 issues, which, being relevant, are reproduced herein under page 39. Full stop. At this stage, it is very pertinent, full stop. On behalf of the plaintiff, 5 witnesses were examined, and on behalf of the defendant, also 5 witnesses were examined. The plaintiff exhibited various documents, including the allotment letter dated 5/1/2020, semicolon, the revenue paying receipts, full stop. The defendant exhibited also various documents which were unregistered sale deed, and certificates from the Gaubura. It is very pertinent at this stage to take note of that on 25/2/2020, it is very pertinent to take note of from the records of title suit number 25/2015 that on 25/2/2020, after the evidence of both the parties being over, the case was fixed on 25/3/2020 for arguments. On 19/2/2020, the arguments were completed and the suit was fixed on 2/1/2021 for judgment. The above aspect of the matter has been brought to the no, the said aspect is very relevant, taking into account that the plaintiff expired on when
21.
2/1.
3/1/2021, Lordship.
3/1/2021. And the judgment was pronounced by the learned trial court, decreeing the suit in favor of the plaintiff on 12/1/2021. Full stop. The record further reveals that the appellants herein being the defendants of the suit being aggrieved had the judgment and decree was pronounced on 12/1/2021, thereby decreeing the suit in favor of the plaintiff. Whereby the relief sought for in the plaint were granted. Being aggrieved, the defendants preferred an appeal before the court of the learned civil judge Morigao, being title appeal number 4/2021. The appeal was filed against the dead plaintiff. Full stop. This court had also taken note of the LCR which had been called for. Of both the learned trial court as well as the learned first appellate court.
LCR page 61, there is an petition.
On the filing of the said appeal, the said appeal was a said appeal being titled appeal number 4/2021. While in order dated 10/3/2021, the said appeal was admitted. The record further reveals that on 23/9/2021, the legal representative of the dead plaintiff, of the plaintiff, to one of the legal representatives of the plaintiff, Mohammad Safiqul Islam, filed an application on 23/9/2021. stating inter alia that the plaintiff had expired leaving behind the 5 legal representatives whose names were also provided in the said petition. Subsequent thereto, by another petition on 4/12/2021, an advocate by the name of Mr. N.K. Bora informed the court that on 3/1/2021, the plaintiff expired. On 13/12/2022, the learned First Appellate Court fixed 19/1/2022 for steps by the respondent is further seen from the records that without formally substituting the plaintiff who expired even prior to the filing of the appeal, the learned First Appellate Court proceeded with the said appeal. By hearing the appellants as well as the legal representatives of the respondent of the plaintiff. The record further reveals that by the judgment and decree dated 2/9/2023, The appeal was dismissed, thereby affirming the judgment and decree passed dated 12/1/2021 passed by the learned trial court in title suit number 25/2015. Accordingly, it is under such circumstances the present appeal has been filed. This court further finds it very pertinent to take note of that even after knowing fully well that the respondent, that the plaintiff had expired, expired, and in the appeal, the legal representatives of the plaintiff had participated as the respondents. The instant appeal has again been filed by the appellants herein against a dead person. Be it as it may, the record reveals that again, the legal representatives of the respondent, of the plaintiff, filed an interlocutory application being IAC number 3721/2024. And this court, by an order dated 19/3/2025, again implemented the legal representatives of the plaintiff as respondents to the instant appeal. The appellants further were directed by the order dated 19/3/2025 to file memo parties, file
No, in that order, Lordship, the applicants were directed to file memo of appeal.
you were the
Lordship, so registry is asking me, Lordship, to file the amended cost title. How can I file amended cost title? So my name is not reflected in the cost title, still showing Mohammed Jamal.
Okay. In the backdrop of the above, let this court consider as to whether the substantial questions of law so proposed can be at all be formulated as substantial questions of law involved in the instant appeal. Mr. B. Hussain, the learned counsel appearing on behalf of the appellants, had submitted the following four questions of law, had proposed the following four questions of law to be substantial questions of law. And for the sake of convenience, the same are reproduced hereinunder. The first question of law so proposed pertains to as to whether the impugned judgment and decree passed by the learned courts below was sustainable for declaration of the allotment right and for recovery of khas possession without prior possession of the suit land described in Schedule A. On the basis of Exhibit 1 allotment letter dated 5/1/2020, was sustainable in law. It is seen that both the learned courts below in the impugned both the courts below have concurrently come to a finding that the plaintiff was in possession of the suit land till he was dispossessed by the defendant. This court further finds it relevant upon a perusal of Exhibit 1 as well as the evidence of PW4 and PW5, which both the courts below have duly considered. That the land was allotted to the plaintiff by the deputy commissioner. Which was duly proved. Considering the above, it is the opinion of this court that both the courts below were justified in decreeing the suit. That the plaintiff had plaintiff is a legal allotee of the suit land as described in Schedule A to the plain, as well as for recovery of cast possession of the suit land by evicting the principal defendants, etc. Accordingly, the said substantial question of law, the proposed question of law cannot be formulated as a substantial question of law. Since any perversity shown to the finding of facts arrived at concurrently by both the courts below. The second question so proposed pertains to as to whether the learned court were justified in decreeing the suit when it was barred under Section 154 of the Assam Land and Regulation 1886. This court have duly perused the plaint, the written statement, have duly perused the written statement filed by the appellants. And further, the judgment, the issues framed and the discussions so made by both the courts below. nowhere such a plea had been taken in the suit on the by the appellants. And as such, the same, in the opinion of this court, cannot be a substantial question of law which can be formulated. The third question of law so proposed is as to whether the judgment and decree dated 12/1/2021 passed by the learned trial court in favor of the dead plaintiff who died on 3/1/2021 without the LRs not brought on record over the government land was perverse, and the decree was passed in favor of a dead plaintiff is a nullity. It surprises this court as to how the said question of law at all can be a substantial question of law which can be formulated. More so when the appellants have been consistently filing appeals, the first appeal as well as the present second appeal against the dead plaintiff. Be it as it may, as have been already observed in the previous sections of the instant judgment, the suit was heard on 19/12/2000 when the plaintiff was alive. And the judgment was pronounced on and was heard on 19/12/2020. And the court had fixed the case for judgment on 2/1/2021. And thereupon the judgment and decree was passed on 12/1/2021. By operation of Order 22, Rule 6 of the Code, the question of the appeal having abated, the suit having abated, does not arise. And as such, the question of law so proposed cannot also be said to be a substantial question of law which can be formulated. The fourth question of law which have been proposed is as to whether the suit of the plaintiff was maintainable in law and not barred by limitation under Article 58 of the Limitation Act as per the evidence of the plaintiff witness PW3. A limitation act confirm. What is 58? Is for declaration of title.
Regarding possession, my lord,
Huh?
he admitted that he had no possession over the land within the specific boundary as per Exhibit 1, allotment settlement letter. There was no even settled boundary of the land in the allotment certificate. So he had no possession.
Huh?
The appellant plaintiff had no possession.
What?
The plaintiff who filed the suit had no possession who was admitted because as per his allotment certificate Exhibit 1, there was no mention of schedule of the land with boundary. There was no delivery of possession. That was admitted.
Did the court, any of the courts come to a finding that he was dispossessed when? Have you mentioned when you dispossessed him?
No, any cause of action shown that when dispossessed.
He said in 2013.
That was the request, one the request that you vacate the land. But before that, the alleged that the defenders forcefully dispossessed him long back. While
When?
he was undergoing
Did
treatment.
you show anywhere? It is your limitation. You are raising the issue of limitation
It was the admitted fact of the plaintiff himself here.
regarding.
Evidence PW1. His land was quite different land.
This court have duly perused this plaint and the relief sought for. From the plaint, it is seen that the plaintiff had sought for a declaration that he was a legal allotee. And along with it, sought for recovery of khas possession over the suit land. It is a settled principle of law that as the plaintiff, settled principle of law, it was judgment to verdict, huh? Settled principle of law that when possession is being sought for, where recovery of possession is being sought for, that in a suit for recovery of possession, the relief for recovery of possession shall be taken into account for the purpose of limitation. In the instant case, there is no materials on record as to when the defendant had dispossessed the plaintiff. Except merely stating that they have been in possession of the suit land since 20 years. Taking into account that the plaintiff have been possessing the suit land, plaintiff has a right over the suit land, being a legal allotee, it is the defendant who has to prove that the possession was adverse, and having failed to prove that, the period of limitation, the question of law so submitted cannot be formulated as a substantial question of law involved in the instant appeal. Considering the above, this court does not find any merit in the instant appeal. As no substantial, considering the above, as this court does not find that any substantial question of law can be formulated in the instant appeal, comma, the instant appeal cannot be proceeded further, for which the appeal stands dismissed. The reports so produced, so called for, be returned. Yes, Mr. Lal.
Yes, my lord, there is one CRP, my lord, where my lordship has on 28th February has passed that this court shall consider the legality and validity of the impugn order. Kindly see, my lord, the impugn
Item
order is
43,
22.
updated.
Who is there in item 43? Other side?
M.I. Hussain, my lord.
For the petitioner.
Petitioner, I'm assisting Mr. Lal.
Where's the respondent? You are being,
In court number 6.
huh?
I was in court number 6, Lordship.
Okay, that is why I waited.
I'm sorry, Lordship.
Yes, tell me. He says that 10,000 is too less. Are you paying him the 10,000?
Yes, Lordship, I'm regularly.
10,000 they are paying me.
What is your income?
My lordship, he is a builders, my lordship, consultant. He is maintaining the luxurious car, BMW and Kia car, my lordship. His son is earning, my lordship, more than 70,000 rupees, but he has made a statement in financial affidavit that he is a dependent. 29 years old son has been shown as a dependent. And also, my lord, there are certain financial affidavit he has not given. It is apparent, my lordship. He is saying that he is earning 50,000 rupees. He has a loan of 73 lakhs. He has been paying 30,000 EMI. Once he is earning 50,000, how is giving this EMI loan? How the bank will give loan to a person whose paying capacity is not, my lord? So lot of things he has made. And kindly see, my lords, what he did, my lordship. The petitioner left in 2nd December 2022 from Coimbatore, my lord, and came to Guwahati, native place, my lord. Here she performed her last ritual rites of father. She was not to perform there, my lordship. Her father died at matrimonial home.
Lordship, earlier, the petitioner approached this honorable court by way of filing revision petition, Lordship. That was dismissed, Lordship, by this honorable court. Lordship may kindly find that order at page 65, Lordship.
Page?
Page 65.
Against this order?
Yes, Lordship. Page 65 is the order.
My lord, this is the first order. This honorable court has held, my lordship, it is not maintainable.
By judgment, and here Lordship may kindly see the operative portion at page 73. There was a direction from this honorable court to hear and dispose of the petition at the earliest possible time by the learned family court, Lordship. But what happened, Lordship, while they filed the affidavit of assets and liabilities, they made some false statements. And therefore, the respondent filed a petition before the learned family court under section 91 of CRBC, Lordship.
Thereafter, the learned family court directed the petitioner to produce those records. The petitioner produced those records before the family court. Thereafter, the respondent again filed a complaint for perjury under section 340 of CRPC, Lordship.
Hmm.
That petition is pending for hearing, Lordship.
Where is the impugned order?
Lordship, page 60.
Impugned order is page 22.
Yes.
Against this order, division order, my lord, I went to the Honorable Supreme Court. Supreme Court has directed to file a petition under Article 227. Thereafter, I have filed a read petition before this Honorable Court. My lord, page 74 is the Supreme Court order. He is not giving the correct fact, my lord.
They have withdrawn the petition.
74 is the Supreme Court order, my lord. In compliance, I have filed a read petition, my lordship. Page 75 is the order of this Honorable Court that the read petition is not maintainable under Article 227. But however, you file a petition under Article 227 as per the direction of the Honorable Supreme Court. Thereafter, this petition, present petition has been filed CRP, my lord. He is not giving correct information, my lordship. 91, 90, 340, it is a subsequent after passing this order, impugned order, my lord, where I have moved an application under 91 of CRPC to disclose all the bank accounts.
She is a single lady, Lordship. She has no issues, Lordship.
She has no siblings. She is living alone, my lordship.
10,000 is given by the learned family court appreciating all facts, Lordship. And the falsity she has stated before in affidavit, assets and liability, that was known by the respondent later on. Therefore, he filed petition under section 91 CRPC. And when the petitioner produced those records before the learned family court, the petitioner, the respondent again filed a complaint under section 340.
Mr. Lal,
He is
tell me
also
one
not
thing.
with
Just
clean
yes,
hands.
yes.
Sorry, Lordship.
Yes, my lord.
kindly come to page 56.
56, yes, my lord.
These assets and liabilities which are there at page 52, okay?
56, my lordship, it is the financial affidavit of the respondent.
Very well.
Yes,
Who
my lord.
has overwritten over that?
Where, my lord? Page number 56.
Details of the loan, bank details, not
Details
clear
of the
mention or ITR.
Details of the loan taken or given, he has.
No, who has written all these handwritten things?
My lordship, the same.
Who has
copy
written
they
all these
filed.
things?
My lordship,
What is all these things? Tell me.
While
Kindly come to page 52. What is written out there? Nobody knows. Kindly come to serial number C2. It is not
C2.
incorrect to mention the dependent. What is this? What type of petition is being filed out here?
my lordship, this annexure has been filed, my lordship. It is not there. The local
I
lawyers
will
were making.
disregard. I will now consider it without disregarding this document. So I will not consider this document. Okay.
Yes, my lord.
Now, without considering, tell me what is wrong with that order.
Yes,
now.
my lord.
What is wrong?
While passing the impugned order, my lordship, the
What is
parameters,
wrong?
my lordship, for granting
We will
the.
not consider the assets and liabilities.
Yes, my
This
lord.
document at page annexure 50, page 51, page 60, I am not going to consider that. Without considering that, tell me what is wrong with that order.
Yes, my lord. My lord,
I
he
don't
has-
find any wrong in it.
kindly see, my lord. Page, page 53, my lord.
Again, I'm telling you, Mr. Counsel, I'm
Yes.
not going to look into page from page 51 to page 60.
Page 51 to 60, the entire
I'm not
financial
going to look
affidavit.
into it.
Entire
All are handwritten over it. Why should I look into it? What is the veracity of this document?
I mean, lords,
And
then,
who has certified it? Who is
again,
this?
give me permission to replace
Yes.
these documents, my lord.
Yes, sir.
How can you certify something which is overwritten?
My lordship, inadvertently, this
52,
document has
kindly
been.
Huh? How can you
It's a
certify
handwritten
this?
Let me allow me to file it fresh, Lord.
Huh? How can you certify these type of things? Tell me. Yes,
I was under the
here,
impression this is a-
C1, this son is adult and not dependent on respondent? Means what is the veracity of this? Is it just to influence this court by writing all these things?
It must have been come with the office copy of the council, my lord, of the below the.
But how can you file it?
My lord, I'm
Certify it to be true.
apologize for that, my lord. I'll file it afresh, my lord.
Will permit me to replace this document, my lord. Lordship.
And where is your assets and liabilities? Where is your assets and liabilities?
It has been filed before the family court, my lordship.
Why
Financial
haven't you filed it here? So you mean to say that you will do it one-sided?
It will be placed before my lordship. The record of the family court may be summoned.
Why should I call for the records of the family court? Isn't it your responsibility to bring on record that
Yes,
both of it?
Yes, both of it. Lord.
Then?
I will place on record, my lord. I will place on record.
List the matter again.
I apologize, my lord, for
18,
inconvenience to this honorable court.
2025. In the meantime, liberty given to the petitioner to bring on record by filing an additional affidavit, the certified copy of the statement of the affidavit of statement and assets filed by both the petitioner and the respondent before the learned family court.
Obliged, my lord.
Obliged.
Any short date, I will request, my lord.
Huh?
Any short date, I will request, my lord.
No,
It's
first of all, you
2000
do that, then only.
I will do that, my lordship, within
You
2
do
weeks.
Mr. Lal, kindly don't take further advantage. You have taken the advantage of an upgrading this matter, and after upgrading it, this is what I
I
find.
apologize, my lord, because of this document inadvertently filed, my lord.
If you want an order, I can pass an order that the matter stands adjourned, synodized till filing of this such affidavit. You want that?
I no, my lordship, I am sorry.
No,
The
I'm giving you a
convenience
good
imposed to me.
Yes, what is this?
Sir, this is a second appeal your lordship will find, my lord. Reversal, my lord. Reversal. Suit filed by the plaintiff, we are the defendant, my lord. This is a, my lord, joint family property.
You are on
Yes.
caveat, Mr. Alam.
My lord, I'm appearing for expert number 1
How?
by filing.
Okay, we have not issued notice.
No, my lord, we have come to know regarding filing of this appeal from the executing court and accordingly appeared, my lord.
Yes, what is your case? What are the substantial questions of law?
Case 10, your lord.
Huh?
The suit filed by the plaintiff was dismissed by the trial court on the ground, my lord, that the co-sharers are not made parties.
Where are your substantial questions of law?
At page 10, my lord.
10.
At page 10 of memo.
Yes.
My lord.
What co-sharers are not parties?
Yes.
Huh?
Yes, my lord. And
Who are the
that-
co-sharers?
That aspect of the matter has been ignored by the learned appellate court, my lord, number one. Number two, my lord, the partition suit has been decreed, my lord, without, my lord, passing a preliminary decree, my lord,
Huh?
by the first appellate court.
Without?
Making a preliminary decree, my lord, under order 20, rule 18, CPC, my lord. Under order 20, rule 18 of CPC, my lord, all the co-sharers in a partition suit, my lord, partition has to be done, and, my lord, in presence of all the co-sharers. Here is a case, my lord, your lordship will find that the
First of all, Mr. Sen, the second thing which you are saying is makes no sense. The question of a preliminary decree is not required, considering the fact that these are all revenue paying state. Here the decree, they will ascertain the shares and then it will be sent out there for the court to be done in that manner. Then it will be done. That is order 20 rule 18(1). It is when some property which is not accessible to public revenue, then only preliminary decree is required. Isn't it?
correct.
Now here the entire property, we are not concerned with any house or anything. We are only concerned with the land as per schedule A, B, C, D. So it will come under order 20 rule 18(1).
18(2), 18(2).
Read it.
If
18(1) says, if
18
and
18(1)
insofar as a decree relates to an estate assessed to the payment of revenue to the government, the decree shall declare the rights of the several parties interested in the property, but shall direct such partition or separation to be made by the collector or any other gazetted officer subordinate of so and so, and on that behalf in accordance with the direct declaration and with the provisions of section 54. Now this property is revenue saying payment of revenue. Okay. Okay. Now the second comes in, if and insofar as such decree relates to any other immovable property which is outside the revenue saying. Just for example, there's a building. There's a building out there. How do you do it? You then have to have a preliminary decree. Where is it? In the suit? I don't see it.
the suit, there is a building.
Where is it?
Building, my lord.
Where is it? Mentioned in the suit.
My lord, in the plain, written statement we have stated
That
that there is a houses, buildings over the land. Therefore, my lord, a preliminary decree is required for the purpose of determining the share and, my lord, the possession of the land. Unless that is done, my lord.
okay, we can very well consider this to be a preliminary decree. Then doesn't make it a substantial question of law. We'll say it to be a preliminary decree. Then
But they are not, but
you have given the names of the co-sharers,
yes,
no?
yes, my lord, I have stated in my.
Paragraph 5.
Yes. And learned trial court has, my lord, rightly dismissed the suit on that ground alone. Not going into the other aspects of the.
Yes, Mr. Alam, what is this?
My lord, there is no specific pleaded regarding non-renewal of necessary parties. My lord, one submission has been made that over the suit property there is RCC building. The lordship may kindly to see the schedules mentioned in the WS, no structure has been shown in over the subplane, my lord. Page 29, my lord. These are the schedules shown in the WS. No single structure has been shown.
But my lord, the photographs that we have to give.
No, no photographs, no pleadings.
Subsequently.
And what about what about paragraph 5 of the DBS? Where is your statement that it is not by, where is your statement in your plaint about the necessary party? Where is your statement in the written statement? Necessary party? Where?
Number 5, my lord.
Paragraph number 3.
Son Ali enjoyed 3 visa.
I'm not on that. Come to paragraph number 3.
Defendants and performer defendants are the co-partners of the suit patta. Each of the co-partners peacefully enjoyed their respective.
Your own case. Why you are raising these type of issues? Substantial question of law. So 1 and 2 goes. Now comes to 3.
My lord,
And when it come to 1 and 2 is finished and we come to 3, it further weakens. No, absolutely no. You were supposed to mention who are the parties. And you have yourself admitted that they are the only co-partners.
my lord, paragraph number 5. We have.
Paragraph number 5 is not there. Nothing to do paragraph number 5. No, no. Well,
Kindly see the trial court judgment.
no, I'm not going to look into the trial court judgment. You see, first of all, where have you mentioned out there in your plaint, in your written statement?
Paragraph number 5.
What did you say?
Yes, my lord.
Yes.
That one Hassan Ali enjoyed 1 patta 5 acres of land within the suit patta till his death. Said Hassan Ali died leaving behind.
But the plaintiff
one-
failed to make Dulal Mia, Bilal Hussain, Hilal so and so in the suit. Hence, the plaintiff's suit land is bad for non-joinder of necessary party. Yes, Mr. Alam. What today? With
Hello.
5?
Well, in view of admission made in para 3, my lord, this paragraph is not having any legs to stand, my lord. This is the.
Understood. But what do you say? Can there be a partition suit?
My lord.
Partition suit without all the partners?
No, my lord, the plaintiff have not.
Wouldn't that the distribution of shares which is being
My lord,
done?
the plaintiff has not sought for partition, my lord, by right of inheritance from the co-partner. By right of purchase, my lord, the partition has been sought for.
Huh?
By right of purchase, my lord.
Right of purchase,
Purchase, my lord.
No.
not by inheritance.
Inheritance. Absolutely inheritance.
Your lordship cannot see the finding of the land at appellate court recorded at page 19, my lord, 90.
Who is Hassan Ali?
Hassan Ali is the my lord, son of the.
Hassan Ali is the brother, is the father
Father.
of the plaintiff,
Yes.
Of the plaintiff.
of the plaintiff.
Yes.
So the plaintiff is asking for what?
For partition, his share of land. Without
Declare
making
of his
party.
right title in man and
Other
declare
court, yeah.
confirmation of possession on the so declare confirmation of possession over the Schedule C land out of Schedule B land in favor of the plaintiff. So if they are asking for partition, can B and C be granted? No.
No, my lord, the partition has been sought for by the plaintiff, my lord.
No,
Son of-
if he is asking for partition
My lord.
on the basis of he is the son of a, or did he,
Hassan Ali.
Hasan Ali,
Hasan Ali.
then can he ask for this BNC? And if BNC is to be given, the BNC cannot be given unless there is a partition.
BNC is the part and parcel of Schedule A, my lord.
Huh?
And BNC is the part and parcel of Schedule A. And BNC was the property, my lord, of Hasan Ali.
How?
Inherited by the plaintiff, my lord, and all
No,
the-
no, Hasan Ali is the self-ownership.
He had also acquired, my lord, by right of inheritance.
If he has got it, then how can there be a preliminary decree? Then because of B, D, prayer D and E, D and E, first therefore there has to be a preliminary decree. Then the partition has to be given. Then only this confirmation of possession can be given. Isn't it? Huh? Mr. Sen has been able to make out the case.
My lord, here in this case, my lord, plaintiff has sought for partition of his share by right of inheritance from Hasan Ali.
Understood.
All the legal aids and successors of Hasan Ali are on record, my lord. All of them are on record, my lord. So plaintiff has not sought for any partition.
Leaving behind Fateh Biwa, 7 sons, Halil Bia and all these things, it is a fact that Fateh Biwa has already expired. Although the plaintiff made Fazol Has Iman are parties, but the plaintiff failed to make parties Dulal so and so, so and so. Who are these? Dulal Mia and all? Who are these Dulal Mia and all?
Legal heirs of this.
Hasan Ali, my lord. Hasan Ali.
How? How? Failed to be made parties.
Paragraph 5 we have stated.
Huh?
Paragraph 5 of the.
Paragraph 5 also I am not able to get it. It is a fact that Fateh Biwa has already expired. Although the plaintiff made Fazal Haq, Asghar Ali, Imam Ali, Rabia Khatun as parties, but the plaintiff failed to make Dulal Mia so and so in the suit. Who are these?
The legal heirs of Hasan Ali.
How do you say so? You say out here, Helaluddin, Bilal Hussain, Fazal Haq, main defendant number 1, Asghar Ali, Dulal Mia, Imran Ali, so and so, plaintiff number 4, plaintiff, and 4 daughters, so and so, others died. So from there, they have not made Dulal Mia, Bilal Hussain. You have not made these people party.
Why cannot the learned child judge has complete conclusion law that without making them passing law, the decree cannot be allowed.
How does the first appellate court deal with this aspect? Which is the issue as regard non-joinder of parties?
Is there a trial court judgment, Melody, your lordship will find?
Lordship, the correct see page number 90, page 91, my lord.
Page, my lord. 39.
Huh?
39, my lord. Paragraph 10A.
39. No, what is the issue?
Page 39, my lord. Page 39 are the issue.
Whether the suit is bad for non-joinder of necessary party. That is an additional issue.
Well, it was additional issue. Frame, my lord.
on the basis of the pleading.
How is the additional issue decided and how does the first appellate court?
Yes, the additional. issue
Ah, yeah, yeah.
decided-
Page 42, paragraph 42, page 89. Purchase of the land by the plaintiff from Iman so and so is an, as such, the plaintiff is claiming the relief of partition of his purchased land only by registered sale deed, as such non-joinder of other area will not affect. So page 91.
91.
So you are
Yes, sir.
asking only in respect to this,
This much of property, my lord,
not the others.
not others.
This you have purchased by
Purchased
yourself.
by the registered sale deed, my lord, which is not in dispute.
Declare the degree that plaintiff has right idea over the schedule B land to be the. So this is something similar where a person must have purchased from some co-owner.
Owner,
You have purchased it.
purchased, my lord.
And after purchasing, you sought for partition.
Partition
So
and
this
declaration
is-
of title.
So dismiss. Dismiss.
No,
One, two goes.
No, my lord. The fact remains, my lord, your lordship can just in the evidence of record, page 90.
Hello. Mr. BK Sen does not stop with one. Okay, we come back on another day. When? On that day, we finish it up. When? The fateful day of this 35 has to end.
My lord,
We have it on 23, 22,
first week of June. my lord.
22. The reason is 33 minus 22 is 13. Okay? This is the matter on 22nd of May at 2 p.m.
Yes, your lord.
Where are substantial questions of law?
Copy to digital to my. I have not even served with a memo with bill.
First of all, are you on caveat?
We have appeared in the.
Condonation application.
Yes, sir. Only one for one respondent.
Huh?
Respondent number one. It is also different. Yeah. Then I will serve a copy, your lordship.
There's no stay.
No, sir.
You appeared in the delay condonation. On Asani. Yes, where are the substantial questions of law?
Your lordship may kindly. Page 4. Last, your lordship, 2. Yeah, read your lordship. Down below, your lordship. That the following are the substantial question of law involved in the instant appeal.
When was the suit filed?
Suit was filed year 2005, Your Lordship.
And your names were recorded in the revenue records in 1988.
88, Your Lordship.
And how is that aspect taken into account on the question of adverse possession?
Your Lordship may kindly peruse page page 57, Your Lordship. Para 39. May I read, Your Lordship? Page 57, para 39.
Are you recognizing the ownership of the plaintiff?
Your Lordship, in this case, I am not recognizing the ownership because it's with respect to title. And this title has been granted on the basis of a Jamabandi, records of rights, Your Lordship. So they have failed to establish that they have a title. Only with
Huh?
records of rights, the decision that he has the title, when decided on the basis of records of rights, Your Lordship. No other evidence, Your Lordship, except the copy of the records of rights, copy of the Jamabandi. The appellate court came to a finding, Your Lordship.
But if you are not recognizing that the plaintiff is the owner, then the question of adverse possession does not arise. So the third question, substantial question of law does not
Does
arise.
not- In my,
So it will be one. On the basis of which, as to whether on the basis of that evidence
Yes, sir.
it has been done. So the suit was decreed
Yes, your lordship.
on the basis of
They have failed to establish their proof, your lordship.
mutation entries, record of rights. Record of rights.
In appeal, it was decided by the appellate court, your lordship, the record, on the basis of records of rights. Your lordship may kindly peruse page 51. Page 51. There are 26 onwards, may I read, your lordship?
That I have read it.
Yes, sir. I'm relying on the judgment of the Supreme Court, your lordship. Relying on paragraph number 15, your lordship, 15 to 20. May I read, your lordship? There 2014 Supreme Court 937. your lordship.
The PDOE, the learned counsel appearing on behalf. Appellate. With an appeal under section 100 of the Code of Civil Procedure 1908. Challenging the judgment and decree dated 2/7/2014 passed in title issue number 5/2015, whereby the suit being title suit number 123/05 dated 13/12/2012 was decreed in favor of the plaintiff. The instant appeal is admitted on the following substantial question of law: whether the learned court, First Appellate Court, was justified in decreeing the suit in favor of the plaintiffs merely on the basis of the entries made in the Jamapandi, that is the record of rights. Question mark. Not adverse possession, you are not.
No, I'm not placing adverse possession, your lordship.
Steps be taken upon the respondent by way of registered steps be taken. How many respondents are there? How many people died?
Only one respondent is appearing before this court, your lordship.
You are there. Struck off. 2 and 4 is struck off.
Yes,
Nah.
sir.
Why 2 and 4 are struck off?
There is an order of this honorable court 5/4/2021.
Okay, I somehow.
I number 806/2021.
I number 806.
2021.
Why respond number 2 and 4 has been struck off? Are they not the plaintiffs?
Yes, your lordship.
Huh?
Yes, yes, your lordship. Sorry, your lordship, I don't have the order.
Two and 4 has been struck off. What about 3?
3 they are appearing, your lordship.
Huh?
3 they are appearing.
No.
3.
Only I am appearing for the response number 1,
Hatim Ali
Fatim Ali.
and Suzanne Ali, who is he?
Like,
You police.
Rupal Ali, Rubjan, brother.
Rubjan is dead. Hussein Ali or Suzanne Ali? They put the wrong name, na? Hussein Ali.
I am appearing only for response number 1, Hatim Ali. My God.
Hussein Ali. Now, steps be taken as regards to response number 1 and 3. So Mr. D. Chaudhary appears on behalf of the response number 1 and accepts notice. And as such, there is no requirement of taking further steps except serving an extra copy of the memo of appeal upon him. As regards the response number 3, the appellant is directed to take steps by way of registered as well as usual. First, call for the LCR. Case 70. This is an application filed under Order 41, Rule 5 of the Code of Civil Procedure for stay of the impugned judgment and decree dated 2/7/2014 passed by the learned civil judge Nagaon entitled Appeal number 5/2014. Taking into account that the accompanying appeal has already been admitted by formulating a substantial question of law, this court and further that the state decree is an executable decree, this court stays the judgment and decree dated 7/4/2014 passed by the learned court of the civil judge Nagaon entitled Appeal number 5/2013 till the disposal of the accompanying second appeal.
I'm very grateful, Your Lordship.
Item 14.
Substantial question of law. Page 11, substantial question of law.
Suit has been filed and the counterclaim declared, suit dismissed, counterclaim decreed.
If it's against concurrent finding. My lord.
There's a counterclaim.
Yes, my lord, counterclaim is there and it, my lord, it went against of the.
Counterclaim has been decreed.
Yes,
Suit has been filed. What is the value of the suit?
my lord, the value of this suit is. My lord, it is 65,000. Total, proposal judicial suit is valued at 65,000.
55,000.
65,000.
And what is the value of the counterclaim? Why have you enclosed all these things?
My lord. No, because execution has already been filed, so my lord, the records.
Huh?
Execution has already been filed in my lord for that reason.
This value there, okay.
My lord,
65,000, 2,525 is the court fee.
fee, my lord.
And how much court fee you have paid here?
Lord, I have paid 40 in my lord. Same, my lord.
Madam, you are not challenging the counterclaim.
My lord, counterclaim is not decreed, my lord. This counterclaim is not decreed, my lord.
What has happened?
My lord, the
Where is the trial court, first appellate court judgment?
first appellate court order, my lord, is page 13.
Page?
13.
So your suit has been decreed.
My lord. My lord, the suit of the plaintiff filed by the plaintiff is respondent number 1. My lord, it was decreed in favor of the plaintiff, my lord. And
And the counterclaim was dismissed.
my lord, dismissed.
Your counterclaim was
Yes, dismissed,
dismissed.
my lord.
What was your counterclaim for?
My lord, page, my lord, 94. My counterclaim was to dismiss the suit of the plaintiff, my lord, to pass a decree in favor of the defendant number 1 with direction to the plaintiff to execute the process of transfer of the suit.
Pass a decree in favor of the defendant number 1 with the direction to the plaintiff to execute the process of transfer of the suit land, including the associated building documents in the name of Iman, to direct the plaintiff to liquidate the bank loan of the building in the suit. And what was the plaintiff suit for?
A plaintiff, my lord, the suit of the plaintiff was. It was for declaration, eviction, delivery of khas.
Plaintiff's right title and interest over the suit land
Page
and
17.
standing burden when number 1 is merely a trespasser and he has no right title, eviction and delivery of khas possession of the yard. Now you have admitted that the plaintiff is the owner of the layer, suit land.
Yes, my lord, partially admitted, and for that reason, my lord, respondent number two, in the, my lord, in the respondent number two to respondent number 17 were made party, who are the original owners of the land, my lord, but they have not appeared, my lord. And here in this case, my lord, does not appear before the court, and it proceeded ex parte against them.
Paragraph 3 of your written statement,
Yes, my lord.
you have admitted.
My lord, with regard to the RCC building.
No, you say, no, paragraph 3, page 95, that in paragraph 3, it is
Yes, ma'am.
partially admitted that the plaintiff is the owner of the suit land pertaining to so and so, so and so. In the plot of land, there is an RCC constructed by the plaintiff. So you have admitted this.
Yes, my lord.
So then how would this substantial question of law at page 9, 11?
Yep.
1, 2 will arise. Three will arise, 4 arise.
My lord, here it with
Now
regard to
you are challenging the counterclaim here, number 4. That is
Yes.
why I put you the question. If you are challenging the counterclaim, that the rejection, you have to pay the court fee. You have not.
my lord.
Then
My lord, with regard to paragraph number 3, page 95, I have partially admitted, my lord, it
you say,
Yes.
admitted that the plaintiff is the owner of the
But-
suit land,
but yet
measuring 1
measuring-
katha so and so. Where is your denial?
Yes, my lord. I-
Well, who cares?
Because
Unless you say that you, okay, you, as regard the counterclaim, if you have a case. You have a case, no case.
counterclaim, my lord, because with regard, I have not paid the court fee, that is an immediate part.
Huh?
With regard to the counterclaim, my lord, that has not raised a substantial question of law also. With regard to the counterclaim.
No, substance, that is the number 4. Although not properly done, but then also.
I admit not.
And therefore I'm saying, you see, in view of paragraph number 3 having been admitted, 1, 2, and 3 has fallen like a pack of cards. Now, without 4, you need to frame proper question of law and challenge the question of the counterclaim. That is the only way out.
And with regard, my lord, with regard to that 1, 2, and 3, my lord, the learned first, the trial court and the first appellate court, my honor, has clearly stated that though the defendant number 1 has failed to produce the sale deed, has failed to produce the sale deed, the admission on my part with regard to the receiving of money on the basis of the land of 20 lakhs, of me be submitting 20 lakhs rupees to defendant number 1 on purpose of the land is admitted on that ground.
So therefore, you have to go on the question of counterclaim.
On to counterclaim.
Why this is formulation of a wrong questions.
Yes, or with regard to substantial question number 4 and with regard to court.
No, 1, 2, and 3 have gone. It's of
Yes.
no use.
Yes.
You have to go for 4.
4, yes.
4 means you have to go on the counterclaim.
Counterclaim.
So for that, you need to do one thing. You have to pay the court fee for the counterclaim and then come.
Yes.
Miss S.G. Bora, the learned counsel, S.G. Bora,
Yes,
what is
my
your
lord.
name? S.G.
S.G.
Bora,
Bora.
learned counsel appearing on behalf of the petitioner. Appellant submits that the instant appeal is directed against the judgment and decree dated 21/3/2025, passed in title appeal number 15/2024, whereby the learned first appellate court had affirmed the decree passed in, have affirmed the decree passed in favor of the plaintiff and had also affirmed, had affirmed the judgment whereby the learned first appellate court had affirmed the judgment and decree dated 26/6/2024, passed in title suit number 64/2021. Full stop. The learned counsel submits that while the learned trial court, that is the court of the learned civil judge, Junior Division number 1, Lakhimpur, while decreeing the suit of the plaintiff, had also dismissed the counterclaim. First up, the counsel for the appellant further submits that the instant appeal is directed against both the decree, is directed against the decreeing of the suit as well as the dismissal of the counterclaim. Full stop. Taking into account the above, this court have duly taken note of that the instant appeal can be instant taking note of the above, the no, it is the opinion of this court that one appeal can obviously be maintainable against the judgment against decreeing of the suit and dismissal of the counterclaim. But however, the appellant is required to pay the necessary court fee for the counterclaim, which have not been paid, as is apparent from the records. Gustav, list the matter before Gustav. The registry is directed to intimate the learned counsel appearing on behalf of the appellant as to the amount of court. Ms. A.G. Burwa submits that the appellant is ready to make payment of the adequate court fee. Considering the above, the registry shall intimate the appellant, the counsel for the appellant, as to what additional amount of court fee is required to be paid. And upon such intimation, the appeal be the appellant is given the liberty to make such payment. Gustav, failing making of such payment, this appeal shall be only construed as an appeal filed against the judgment and decree passed in favor of the plaintiff in the suit and not the counterclaim. Gustav, list the matter again on 2nd of June 2025.
My lord, I will be making the payments. Can it be in the next week, my lord, because the execution process has already been issued. Next.
No, not next week. We'll have it on 21st of May. 21st of
My lord,
May.
with due apology.
You saw
21st
this
of- my lord,
order
my
before the,
lord,
madam,
another
you
21st of May, my
madam,
lord,
I
after
tell you, you
this,
show this order before the learned trial or executing court, they would not do anything. Don't
My
worry.
lord, any other day other than 21 abstention case.
Okay, 23rd.
23rd, obliged.
15,
And you formulate press questions of law. Yes, what is this?
The regular second appeal, my lord. The main question in this case is that, my lord, whether long possession of a co-sharer will extinguish the title of another co-sharer over ancestral plot of land. my lord. That is the question, my lord. Lordship, we are the plaintiffs, my lord. The case is like this, my lord. Purpan and Juran, they were the original Pattadars, my lord. They were both brothers. So, the total land, my lord, was around 4 bighas. Purpan's share was 2 bighas. So, my lord, Purpan married twice. The defendants were the sons and daughters of the first wife, and the plaintiffs are the sons and daughters of the second wife. So, my lord, as per the Mohammedan law, my lord, after the death of Purpan, my lord, the plaintiffs are entitled to around 1 bigha, 1 katha, 2 lesas of land. Defendants are entitled to around 4 katha, 15 lesas of land. Now, our case was that in the middle of 2012, the defendants illegally trespassed into the suit land. So, we filed a suit praying for partition as well as joint kind of title.
Mr. Das, we take it up on some other day. Taking into account so many second order 41 rule 11 is not permissible to be done on every day. Let us have it on 16th of May.
16th of May, man.
Leave the math on 16th.
For orders, item 16.
None has appeared on behalf of the appellant on call. It is further relevant. Miss B.
B.
Chaudhary
Chaudhary.
appears on behalf of the respondent.
Number one,
When he died,
he died on 16th day of February 2022.
principal respondent.
Yes, I'm for the principal
Huh?
respondent. Respondent number one, principal respondent.
Respondent number one.
Yes, I informed the concerned council within the statutory period, 9th May 2022.
When did you inform?
9th May 2022.
It has been submitted that it is seen from the from the order dated 1/3/2024 that the counsel appearing on behalf of the appellant was duly informed about the death of the principal respondent in the year 2022. And time was sought for to do the needful. However, there appears to be no steps taken in that regard. Considering that the plaintiff had expired, who is the principal respondent, the instant appeal cannot proceed. So accordingly, the instant appeal stands closed as it is abated, the LCR be returned by the registry within after 90 days from the date of the present order.
17.
What is this?
I for combination of earlier 30 days.
How much?
30 days.
Paper publication done. Okay, this is an application filed under Section 5 of the Limitation Act for condoning the delay. Condoning the delay.
That is pertaining to stay, your lordship. Second item.
Huh? No, item number one. No. Operation. Say na kayo ng petition. Construction iman niya position. This is an application for condonation of delay of 30 days in preparing the instant appeal. So it is seen that the service have been duly affected upon the respondents. Then this is an application under Section 5 for condonation of delay of 30 days in preparing the appeal against the judgment and award dated 28/3/2017 passed in MSC case number 1267/2012 arising by the learned court of learned member MSCT Kamloop Metro, whereby an amount of ₹16,05,000 along with interest at the rate of 6% have been awarded in favor of the claimants. It is seen that the service is duly complete. Further to that, taking into account the reasons which have been assigned in paragraph number 5, 3, 4, 5, and 6, it is the opinion of this court that the delay of 30 days have been duly explained. So considering the above, the delay of 30 days is condoned, I stands allowed. the registry is directed to register the accompanying appeal as well as the interlocutory application and list the matter before the court.
18.
You will kindly see the last order, man. But I have obtained the certified copies of the last orders, man.
So it is at the stage of appearance.
Yes, ma'am.
What is the matter about?
Matter, my lord, amendment prayer was rejected, my lord. Thereafter we filed this here. Amendment prayer was rejected.
Oh, what was the stage?
Stage was evidence, ma'am.
Other side has not appeared.
No, my lord.
What is your
We
due
took steps,
diligence?
my lord, the notice expired.
Huh?
We took steps, my lord, notice is expired, my lord. There is an office note.
Huh? Who expired?
Notice, my lord. By the time it reached the office of the Munsib, my lord, the notice expired. That's what we will have to take fresh steps.
Upon?
The respondent, my lord. Sole respondent.
Stop. ঠিক হয়েছে। The PP does the, as the PP,
As does
as the learned counsel appearing on behalf of the petitioner has drawn the attention of this court that the suit presently has been transferred from the court of the learned civil judge, senior division Kamrup Amingao to the court of the learned civil judge, junior division Amingao, and have been re-registered as title suit number 82/2024. In that regard, the order sheet of the said suit being title suit number 82/2024 is placed before this court pursuant to the directions passed on 30/4/2025. The same is kept on record and marked with the letter X. Gustav. This court further takes note of that the present application, by present application and order dated 24/6/2019 has been put to challenge, whereby the application seeking amendment of the written statement plaint was rejected. Full stop. The record further reveals that there was no stay granted. Full stop. However, taking into account the above, list this matter again on 4th of June 2025. Full stop. The petitioner is directed to effect service upon the respondent by way of the stay routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. Till the next date, the further proceedings of title suit number 82/2024 remains pending before the court of the learned civil judge, junior division Kamrup Amingam shall remain stay. All names are different. This is Kaushik Das versus Pankaj Kumar Jain.
Yes, ma'am.
What is this name? Kamakya Prasad Das versus
Madam,
Keshav Thakuri.
They did not contest, my lord.
Huh?
Only one contest.
The name is different of the suit. Are you sure? Here the case is Kaushik Das and another
Yes.
versus Pankaj Kumar Jain. And the certified copy which you have brought in is Kamakya Kumar Das Prasad Das versus Keshav Thakuria. Huh? How is it possible?
Kamekha Prasad, Annexure 1, my lord. 11, page number 11.
Kamakha Prasad Das. This is the suit. Who are you, Kaushik?
And the sons of Kamakha Prasad Das.
It is continuing in that. In Keshav Thakuria. And here, why have you made Pankaj Jain?
Only Pankaj Jain, my lord, contest.
Number 6.
Number 6.
Why not others?
Others, my lord, did not contest, my lord.
Chalo.
Highly obliged.
I know I'm the new engaged counsel of Appellate.
Huh?
I'm the new engaged counsel of the Appellate.
Appellant number 137 have died. You have not taken any steps.
Don't know, my lord. I have got the
The counsel appearing on behalf of the appellant appears to be unaware
I just got,
of what has happened.
my
in the
lord, I
matter.
just got the NOC from my this is.
Accordingly, leave the matter after 2 weeks.
20,
Yes, there's some defect. Why haven't you removed?
My lord, I have rectified the defect, my lord, and I have instructed my clerk to submit it.
Defect in the interlocutor bearing filing number. So and so have not yet been rectified. Why?
I have rectified it, my lord. I miscalculated the days of delay, my lord. I have rectified it now,
When?
today,
Mr.
HK Borua, my lord.
HK Borua appearing on behalf of the applicant submits that the defects have been duly rectified. Accordingly, the registry shall do the need.
Obliged, my lord.
21,
Dated 5/5/2025, service has not been completed upon respondent number 1, 2, 3, and 5. 1 and
Service is not complete.
yes, my lord. My lord, may allow us to take fresh steps. 1
Read the
and
order. What are you challenging?
my lord, we are challenging the order dated order dated 2/3/2021, passed by the additional district judge number 3.
Challenge the order passed by the Imam in which appeal, thereby staying the operation of the interim order of injunction. In the next term, the interim operation of the interim order which is going so by virtue of which the order of the learned trial court will remain before him verified that the order passed by the court. Lot of people have died, not found, service not complete.
Lordship, 1
We
and
finish
5
it off.
used.
You seem to be not interested. We finish it off. This matter.
Hello?
2
Pre-
PM on 19th of May. We finish it off. Service not required for this.
22,
What is it?
Substitution, condonation and abatement. Appellant number 2 died, lordship. 996 is the condonation application.
Appellant number 2.
Yes, lordship.
Is filed within time.
No, lordship, there is a delay of 33 days.
First time.
First time, lordship, other side is appearing, man. He informed me that he will be in court number 9, lordship, Mr. DCC. Pupon.
Delay of
33 days, lordship.
who is he?
Sir, DCC Pupon is appearing for the respondents, lordship.
DCC Fukon. Where is he?
And
33
Lordship,
days out here.
one IA is also pending 2685 injunction. Already status quo was granted there. And
Okay.
on last date, there is an objection that we have not filed any substitution petition in injunction petition.
Why there is the delay?
Lordship, that I have mentioned.
Why?
They were not aware about the procedures, Lordship.
Who is not aware?
The appellants, Lordship. Appellant number 1 is one legal heir, Lordship. She is the daughter, and appellant number 2.1 to be substituted, Lordship.
Who? Who died?
Appellant number 2, mother of appellant number 1. And appellant number 3, another legal heir from another daughter, Lordship. So 2 daughters are already on record. Now only son.
No. Appellant number 1 is the daughter.
Daughter, Lordship.
Then why do you need to substitute?
Lordship, one son is there.
Son is there. It's not a case of substitution. It is not a case of substitution. It would be at best a case of impleadment.
Sure.
Why you're filing all these things? You know, you're an expert in civil law. Where is the question of abatement? Hari cannot abate, taking into account there is already a legal representative out there.
This present appellant, Lordship, who is required to be substituted, Lordship.
What?
He was not earlier party in this case.
Who?
The appellant number 2.1, Lordship, the son.
Who died?
Appellant number 2, mother died, Lordship. So 1 and 3 are daughters already on record.
Isn't it Jamla Khatun died?
Yes, Lordship.
Okay. Jamla Khatun's daughter is who?
1.
So how can there be abatement?
Lordship, at the best I can file one impleadment application.
So we'll consider this to be an impleadment application, allow it.
Lord.
And make 2.1. You want Jaibur Rahman to be there?
Yes, Lordship.
Because appellant number 1 is already there. So the question of
Appellant number
substitution.
1 and 3
Never.
also, Lordship.
All these 3 applications are taken up for disposal by this common order. Hey, I check on the hooks. Common order. So, the appellant number 2 expired on
16/11/2024.
15
16/11/2024.
16/11/2024. And thereupon, these 3 applications were filed on 19/3/2025, whereby seeking condonation of delay for 33 days in filing an application seeking substitution, setting aside of the abatement, as well as an application for setting aside the abatement and for substitution of the legal representatives of the respondent number of the appellant number 2. This court have duly taken note of that the appellant number 1 is the daughter of the appellant number 2. And she is also one of the legal representatives. Considering the above, the question of abatement insofar as the respondent number 2 is appellant number 2 is concerned does not arise. Full stop. It is no doubt true that the son of the appellant number 2 would also be a legal representative. And as such, the application filed under Order 22, Rule 3 can be construed to be an application under Order 1, Rule 10(2) of the Code, taking into account the above, that the appellant, that the son of the appellant number 2
Diabur Rahman.
is also a legal representative, comma. This court substitutes. Is there any dispute with this Ziaur Rahman? He's an adopted son. There is a problem out there.
Lordship, the adopted son, Lordship, they are not disputing, they are not raising any objections.
The appellant number 1 is objecting.
We have filed the wakalatnama for Ziaur Rahman by appellant number 1 and 3 also.
Ziaur Rahman
Ziaur
is, and accordingly, this court strikes out the name of the appellant number 2 and substitutes the Ziaur Rahman as appellant number 2.1. Accordingly, the 3 applications stands allowed by substitution by impleading Ziaur Rahman as appellant number 2.1. Whatever you name it, Naam to silent. His name is mentioned out there. The counsel appearing on behalf of the appellant shall file a fresh memo to parties before the registry of this court, and on the basis of that, the registry shall make necessary changes in the cause title and update in the CIS.
Obliged.
23.
May it please your lordship.
What are these?
Lord, as per office note dated 28/6/2022, there is a report that the respond number 1 and 2's substituted heir also has died, my lord. So a petition for substitution is required to be filed. It's a checkered history, my lord.
Chaudhary, the learned counsel submits that in view of the office note dated 6/5/2025, further steps are required to be taken.
28/6/22.
2 weeks.
24.
May it resolve. My lord, this is the first appeal, my lord, against grant of injunction. During the pendency of the appeal, the plaintiff died. So we had to, my lord, substitute the legal heirs of the plaintiff, my lord. And we also took steps for notices. Perhaps, my lord, notice is yet to be served, my lord, upon the legal heirs of the respondent.
Who died?
Plaintiff, my lord, the sole respondent in this appeal.
You are challenging what order?
My
They have
lord,
been substituted.
yes, substituted.
File a fresh memo of parties. Huh? And have they been served?
No, service is yet to be completed.
I mean, the sole respondent has expired on as such, he seeks some accommodation to take appropriate steps in the meantime, so we are able to file appropriate. Then you filed an application.
Yeah, yes. I
The
have,
notice to the substituted respondents have been issued, but
Yes.
there is nothing mentioned.
yes,
That notice have been received,
the order will be perhaps in the IA, my lord.
notice has been received upon the sole respondent, whereas for newly not have been received. You have not taken steps. Mr. PP Das submits that he would take
Yes, sir.
Estes submits that he would take appropriate steps in terms with the office note dated 28/4/2025. Is the matter after completion of service upon the substituted respondents.
Well, I'll submit amended post title, my lord.
In addition to that, the counsel appearing on behalf of the appellant is further directed to file a fresh memo of parties before the registry of this court, and the registry shall tell it. Date in the CIS will give you date.
25 and 26.
Then What is this?
My lord, contempt. আপনি কখন?
Huh?
My lord, contempt. My lord, your lordship will come to the order dated 4/12/2023, which has been violated by the other side, my lord.
What order?
At page 8, my lord. And regarding the delivery of materials, my lord, and relevant era is 13 and 14 at page 11.
Which have been
13 and 14.
will go to party and meant to be delivered to him and the consignment shall be Yes,
My lord.
you've done?
My lord, may I please your lordship? My lord, this contempt petition which he has filed it, my lord.
Hmm.
Here, my lord, he has named a person, Rajesh Tripathi, my lord. These are, and my lord, whereas the order passed as Annexure 8, it is in the name of a company, my lord, that is the transporter, my lord.
Hmm.
Here, my lord, in this case, my lord, according to this judgment, my lord, a review petition has been filed, my lord. That is the 26, that is the 26 number item. So,
It's a review petition
yes,
filed?
yes, my lord. I have filed a review of this
No,
order
review gonna see
and
that.
he has filed the contempt of this order.
It has been brought to the notice of this court that
Yes,
there
my
is a
lord.
review application filed seeking review of the order dated 4/12/2023 passed in CRP case number 98/2022. So taking into account that the judgment has been passed by Justice, Parthiv Jyoti Saikia,
Okay. The matter with,
list the matter approved before the state court.
with all respect, my lord. My lord, so far the contempt petition is concerned that everything is gone. Actually.
Why should I?
27,
Contempt to likhi dibo, list the contempt also accordingly.
About 26 and 25, 26. right?
What is this?
May I please, your lordship?
This case, my lord, that appeal admitted, my lord, and my lord, that service is a complete, my lord. And my learned, my lord, file application for vacating the stay order, my lord. That, my lord, I am engaged, my lord, that last week, my lord. So, my lord, if that petition, I'll also have to file, my lord, and
Why
objection.
the records of AR is not there?
Record is not yet come, my lord. I have
Okay,
to file
okay.
an
Now,
objection.
whether
Let
the
it
learner
be
have
taken
heard
next week,
beyond
my lord.
beyond the pleadings as well as the evidence, the court while the respondents herein have paid for a decree in respect of dark numbers so and so in Operator, whereas the decree has been passed by the learner in respect of dark number 17 of Pata number. Why the records have not come? Has been issued. It is seen that the records of LCR of the
Trial court record might have come, my lord.
Title Appeal number 47 of the 2022 have not been received. First of the registry shall issue a reminder in that regard. And immediately upon receipt of the records, list the appeal for hearing. Full stop, and liberty given to both the parties to file application for early disposal.
One IA is there.
Taking into account what do you want?
No, my lord, this IA has been filed. My lord,
For
stay,
vacation of
stay order was obtained, my lord, on 13/11/24 in this appeal from this honorable court, my lord. Whereas, my lord, degree was duly executed by the bailiff on 26/9/24, my lord.
You got it.
Position was delivered.
You got it.
I have got the position, my lord.
Well, not actually
Now-
done, my lord. They himself stated that this is not in para 9, my lord. They let the status quo maintain, my lord, if that is so, my lord. Because, my lord, on the same
position-
day,
He has only stayed it.
Stay, my lord.
eight, my lord.
But on a state of stay, my lord, now my position has been disturbing, my lord.
Huh?
They are disturbing my position, my lord.
On 13,
Which
my
has
lord,
been
on that, which.
So
date,
we
my
do
lord,
one thing,
which-
taking into account that the decree has been satisfied.
Satisfied, my
We direct both the parties to maintain status quo.
In terms of the position, report of the bailiff, my lord, 26.
No, as on today.
But even that on that
Have you filed it? Yeah.
objection, I am ready, my lord, that and I am ready to file, my lord, that will file on next opening day, my lord. Objection. Because, my lord, last week I have taken the brief, my lord, from the colleague advocate. And
এটা হেতু এই hearing নকৰিব, huh? The registry is directed to file, remind the trial court, remind the first appellate court about the records and requisition the same at the earliest. It will order hitat hum, huh? I koro dibo, Mr. S.C. Goswami. C. Goswami appearing on behalf of the respondent. Six for appellant, oblique the respondent opposite party in the instant proceedings. Instant application 6 for some time for filing written objection. Full stop. List this matter again on June 10th, 2025. Full stop. This court at 2 p.m. At 2 p.m. Full stop. It is observed that in the meantime, the respondents, the appellants is given liberty to file their reply. Full stop. It is observed that an attempt shall be made to dispose of the connected appeal on that day. If a connected appeal on that day.
Status quo, my lord, as admitted, kind of guaranteed to be made in, my lord.
Mr. Alam, you are a great civil lawyer. Let me ask you, how do I pass that order?
No, my lord.
How do I pass an order in your application for vacating?
No, my lord, I have not.
In your application for vacating, I pass an order of status quo.
Modification, I have paid for modification of.
Modification.
In the light of.
He had asked for stay. Isn't your application for stay?
can already can the order 21 rule 5, order 41 rule 5.
So in that application, how do I grant you a status quo?
My lord, I filed this application, my lord, under section 151 of CPC, my lord. This application is under section 151 of CPC, my lord.
We'll finish it on that date.
Because, my lord, I have been put in position by the bailiff. My lord, I am in position. They are disturbing my.
PO was absent on that date.
They are disturbing my. They are disturbing my.
Mr. S.C. Goswami submits that he will only file, he requires some more time for filing the reply. List the matter after 2 weeks on 30th of May 2025.
No, my lord.
In the meantime, the liberty given to the appellants to file the reply.
But on 29th, my lord. On 30th, I shall on 30th. On 29th.
29 not possible. 28.
28, my lord. 28.
I'm not hearing the appeal.
28.
Item 22, there is an interim order, Lordship. Item 22, Lordship.
What is that?
Item 22, Lordship, that substitution was allowed by Lordship.
Oh, okay.
That will continue.
Interim order is extended.
Obliged.
Item 28.
Hello, here the service is complete. And I have also filed the objection for the respondent.
What is this?
Lordship, our section 8 petition was rejected by both by the trial court as the first appellate court. So we preferred in first appeal against the rejection of our section 8 petition under the Arbitration Act. The ground for rejection was that since the underlying contract has come to an end due to a breach of by one of the party, the arbitration agreement does not continue to exist. So that is not correct proposition of law. But Lordship, the prayer of the suit also maybe your Lordship like this.
Suit? Where's the suit?
Suit it is page 16.
Page?
16 it starts.
Suit for ejectment and areas of rent with mean profit. isn't it?
Yes,
Who are you?
I am a lessee
Tenant.
tenant.
Chief Executive Officer, GSTL. Okay. So you say,
They have filed a suit. I am the defendant there in the
so
suit.
you say that there is an executable, yeah, you say this is not barred under, yeah. This matter came up before me earlier, na? Once.
Once the lordship separate matter came where the prayer for eviction was not there, only for recovery of money.
Ah, here recovery of money, eviction is there. Eviction of what land?
Yes, due to,
So you can, so you mean to say you cannot take the benefit. You would not take the benefit under, if it goes for arbitration, section 5 does not apply. Are you going to take that? The protection which is given to you under 5(1)(e), you don't have it. There's no question of bona fide requirement, nothing. You will go as per the Transfer of Property Act.
if it goes for arbitration, transfer property.
Would you like to go there?
He is the owner.
You have filed a section 8.
Yes, section 8 that it should go, it's arbitrable dispute since because of.
So then it will be only Transfer of Property Act. You don't want the others. Do you know the serious consequences which will happen?
Yes.
Then
Won't get the benefit of the rent control.
no bona fide requirement, nothing is required. You'll go as per the Transfer of Property Act once you are out.
Since the petition was already filed under section 8.
Understood, you may have filed, but this is the big problem.
Yes.
Then please this matter, taking into account that the service is duly complete, this matter has come up for objection, orders. List this matter for admission on 14th of May 2025. We'll finish it off. Take your-
29.
take your on that in term of the past solution till then, because there you have a big problem.
Obliged.
29.
Please, the lordship.
Ah.
As per the office note dated 21/8/24, service has been completed in respect of all the respondents except for respondent number 7.
Except
Except for respondent number 7, who is the pro forma respondent. So his name may be struck off.
service is complete.
Yes, except for the respondent number 7 who has expired,
Respondent number 7 has died.
died.
It is seen that the instant petition has been filed, and this court have duly taken note of the office note dated 21/8/2024, from where it is seen that the service upon all the respondents have been duly affected. So however, as regards the respondent number 7, the said, however, it is also seen that the respondent number 7 had expired. This court further takes note of that the respondent number 7 is a pro forma respondent, and as such, there is no question of substitution. Accordingly, the service being complete, list this matter. What is this IA for?
Substitution, condemnation and.
Huh?
Formal substitution for condonation, my lord, and abatement, my lord, substitution, my lord. 3 IS is there, my lord. Filed
So
by.
accordingly, list this matter again on 26th of May 2025.
Obliged.
30.
In the meantime, the respondents are at liberty to file their objection if any.
My pleasure.
What is this?
Just two IL, okay?
For?
One for is the correction of cost title, and another is additional affidavit.
Huh?
And another is 1416, this is an additional evidence lordship. And 1417 is for correction of cost title.
Earlier, lordship has heard the second appeal, my lord. The second appeal was earlier heard by a lordship, my lord, then it was not listed thereafter for some time, my lord. Now they have filed 2 applications, my lord. One is for reducing the additional evidence, my lord, and another is for amendment in the cost title, my lord. So I believe that, my lord, both these applications may be taken up at the time of hearing this appeal, my lord.
Amendment of the cost title, why?
My lord, they want to bring in the name of one person, my lord, who is the one of the managing director of the
Of
plaintiff, my lord.
so we allow this application? No.
I have some objection with regard.
No, this amendment of the cost title.
My lord, I have some objection because, my lord, what happened, the suit was filed in the name of, my lord, Jawaharlal Muralidhar Properties, my lord.
Ah.
And, my lord, this person, they want to bring in, he was there as a, my lord, Sajjan Kumar Chokhani. He was there as one of the managing partner, my lord.
Ah.
But the trial court as well has held that, my lord.
Have you filed your objection?
I have not filed any written.
File your objection. Mr. A.K. Gupta, the learned counsel submits that he would like to file an objection to stop taking into account that the accompanying applications the present applications are in respect of an RSA, which is 15 years old, 10 days time, a final opportunity of 10 days is given to the respondents to file their objection against both the applications. To list this matter again on 2nd of June 2025.
31,
What is this?
May it please the lordship. Lordship, this is an IA for condemnation of delay, your lordship. Here, your lordship, service has been completed as per office note dated 27/2024.
Who died? Who died?
Lordship, the appellant died, your lordship.
So why there is such delay?
Lordship, it has been mentioned in the delay petition that they were not aware that if the hairs need to be substituted, your lordship.
Huh?
The legal hairs are required to be substituted. It was not known to the appellant, your lordship.
That cannot be the round. I would have considered 341 days, but this is 3,418 days.
I beg your pardon, lordship. Lordship, I am appealing on behalf of my senior lordship. He could not be present before this court today because of his father's death, your lordship.
The counsel appearing on behalf of the appellant, has notice been issued?
Yes, your lordship. Notice has been issued. And service has also been completed, your lordship.
Where?
Your lordship, as per office note dated 27.
Service complete.
Yes, your lordship.
Who is appearing?
Lordship, till now there has been no filing of wakalat number. As I've seen, your lordship, the CI.
So the appeal has not been admitted?
I'm not aware of that, your lordship.
The counsel appearing on behalf of the appellant is not aware of any of the facts. List the matter after 4 weeks.
Much obliged.
32,
Respond number 1 and 2 had died.
Yes, my lord.
As per report, my lord.
Counsel appearing on behalf of the appellant submits that taking into account the office note dated 6/11/2024, he may be permitted to take steps in view of the death of the respond number 1 and 2.
I have supplied their names.
Ms. Swenso appearing on behalf of the Ms. Swenso, who earlier represented the respond number 2, 1 and 2, submitted that in terms with order 22 rule 10A, she has also informed the respondent, appellant, the counsel for the appellant today, and supplied the list of legal representatives of the respond number 1 and 2.
And-
Mr. So-and-so submits that he would do the needful. It's the matter of 3 weeks.
Obliged, my lord.
33,
Lordship, as per office note dated 29/4/25, your lordship, we have taken step, but the respondent number 2, your lordship, she denied to accept the notice, your lordship. And upon the rest respondent, your lordship, notice has been served, your lordship, from 3 to 6.
Who are you?
Respondent number 1. Respondent number 1.
You file an affidavit, this is refused to accept.
Yes, your lordship. Earlier, your lordship, we have taken step, but the respondent number 2, your lordship, she shifted after death of death of her husband, your lordship.
So taking into account the report of the process server, comma, wherein it is being mentioned that the service have been refused by the respondent number 2.1, 2.2, 2.3, and 2.4, comma, this court deems that the service upon the respondent number 2.1, 2.2, 2.3, and 2.4 is duly complete. Full stop. List the matter again on 6th of June, 2025.
34 to 36.
Yes, respondent number 1, 5, and 6 had expired. Again, 4, 5, 6 also has expired.
Yes.
The office notes reveals that the respondent number 1, 4, 5, and 6 had expired, and 13 had expired. The learned counsel, 9 also expired. Huh?
Why? One is RSA 100 and another is 110. 100, RSA 100, miss, IN number 3012. Office note dated 2525, reference number 156 expired.
Died, okay. And in the other one,
110, that's one number 4, 5, 6, and 13 expired. A 10 is personally served.
and whatever address C, 9, R9, huh? Okay. Taking into account the office note dated 2/5/2025. The learned counsel appearing on behalf of the applicants submits that she would take appropriate steps. List the matter of the 4 weeks. Yes, 37.
37.
I've asked you to take
36,
steps.
34 to 37.
Somebody has died, so you have to take steps.
37.
CR has come up. We have also filed one cross appeal that may be tagged together.
You have?
Cross appeal, my lord.
Okay.
That may be tagged together so that can be.
Do you have a number?
That there is a delay contravention, IS civil number 1425 of 25.
Mr. A.K. Sahiwala submits the appearing on behalf of the respondent submits that there is a cross appeal file wherein there is some delay. He therefore submits that the instant appeal be listed along with IA civil number
1425 of 25.
and so list accordingly up on when 12th of 11th of June. 11th June.
38.
Service not complete, leaves the matter up to completion of service. You're appearing?
Lordship, I am appearing for sole respondent. Today
Others?
we have filed the Wakalatnama.
You filed?
Today itself.
38th of Kuribo. Ms. So-and-so appears on behalf of the respondent and seeks for some accommodation.
Lordship, it may be fixed after a week for hearing.
Accommodation for filing objection, if any. So list the matter again on 4th of June. 4th of June? So in the interim order is there?
Lordship, I am not aware.
4th of June.
39.
As per your lordship order dated 23/4/2025.
Service is complete.
Yes.
Your Honor,
Huh?
Your Lordship, I am the respondent, and today itself I have filed the Wakalatnama. And my submission is that, my lord, I have no objection, my lord.
Okay.
If the petition is a lord, I have no.
Full
objection.
phone is it? Okay, all these matters, is there any interim order to be
Yes, Will.
extended?
Yes.
Okay, take the dates, the date di দিব, interim order extend করে দিব। আৰু এইকেইটাৰ এটা চাই ল'বচোন, I'm writing.
Your lordship,
My lord.
your lordship, my submission is that the matter may be disposed of. I have no objection with that.
Okay, as you are appearing, item number 39, na?
13.
Okay, list this matter on 14th of May. 14th of May for admission. And interim order passed earlier shall continue till then. And other matters, you kindly get the order. Other matters, you kindly get these things. So I book your eyes. What is this 40?
Lordship, we have taken steps. So Dosti Lordship, we have also filed Dosti affidavit, which is not in record list.
Trustee file.
Already filed on sixth on Lordship. which
Okay,
is-
এইটো list কৰি দিবচোন একদম 40 এইকেইটা ওচৰত ডেটত লিষ্ট কৰাই ল'ব। interim order আছে নে নাই চাই লওক।